Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here with our continuing coverage of the impeachment trial of Ken Paxton. Ken Paxton, as you are aware, is the elected Attorney General of the state of Texas and has been accused of turning over his office effectively to become the personal attorney of Mr. Nate Paul. So rather than service the client, Texas, he serviced the client, Nate Paul. That is basically the accusation. Not that he was helping Nate Paul to benefit Texas, the client, but he was helping Nate Paul to benefit Nate Paul. That's the problem, right? He was corrupting his office to turn it over to work for a guy for his personal problems rather than to benefit his client, which is a no-no for any attorney. Right? You always have to remember who the client is and always must principally serve the client. Be a zealous representative to the client, right? That is always number one. And you must never confuse who the client is. This is key for every attorney, and certainly no exception if you're the Attorney General of Texas. So basically, in long and short, that he used the powers of his office to benefit Mr. Nate Paul by, among other things, having the Attorney General's office insert itself into a lawsuit involving the Mitty Foundation, a charity, in order to benefit Mr. Paul, by issuing a Attorney General's opinion letter to try to forestall foreclosures to benefit Mr. Paul, and otherwise benefit Mr. Paul in other aspects of the office. So any one of these probably by itself is not enough, but it's the accumulation of the things that's the problem, right? Any one of them you want to write off, but in combination, you have the Attorney General acting personally in a very involved way, including by wanting to make personal appearances in court in the capacity as Attorney General, which apparently he never does in any case. And he wants to make them in some low-level district case involving the Mitty Foundation, right, as just like a sort of like a pro forma motion. And it's like, it doesn't make any sense. But Mr. Paul's name is sort of behind every step of the way. And perhaps the most powerful testimony we've heard so far is from the guy that he hired to be the external lawyer, who was by far and away the most credible, or I just came off the most authentically, like he had nothing to hide and just came off very honestly. And the cross was completely ineffective. He just came off as a very genuine guy. It's like, yep, I was basically honored to work for the Attorney General's office. I wanted to do a good job for my boss. Mr. Paxton was my boss. I was his direct report. He personally hired me. I kept him informed every step of the way because I was his direct report. So he knows all the things, and so forth and so on. So basically the impeachment articles are rounding out. So far we have one. We have our impeachment article number 1 for the stuff with the Mitty Foundation, and we have the impeachment articles relating to the firing the whistleblowers, and it's going great. So that's where we are. So that's what the testimony we've heard so far, and the key question in this is why was Mr. Paxton doing the things he was doing, right? Was he trying to benefit the client, Texas, or was he trying to benefit Mr. Paul? That's sort of the bottom line question. So what is his motivation, purpose, intent behind his action, right? Can the Attorney General do things himself? Sure, but he can only do them to benefit Texas. So the question is, was Texas being benefited? And the benefit to Texas is not at all obvious in the things. And Mr. Paul seems to be directly here in sore things. And his own staff is warning him that Mr. Paul's claims don't really make sense, that, this is a bad look for the Attorney General's office, and it kind of panned out that way. So, yeah. So that's where we're going. Let's impeach Paxton. Well, we already did that, but we're trying to figure out whether or not to confirm that impeachment or not. So, yeah. So let's take a quick look at the articles of impeachment. and just go through where they are in sort of my assessment so far about where we're sitting things, in my humble opinion. So article number 1, disregard of official duty by protection of a charitable organization. Paxton caused employees of his office to intervene in a lawsuit brought by Roy F. and Joanne Cole-Mitty Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation. That's looking pretty promising. Article number 2, abuse of the opinion process. We still have not really heard testimony really about how the Senate chair was the straw requester, and there's some technical legal arguments, so Article 2 is a little iffy. Article 3, where he gave a no opinion letter on this open records request, iffy. Article number 4, misuse of official information, hasn't been proven, right? The idea that Paxton gave out information he wasn't supposed to give to Mr. Paul, the information that he had, Mr. Paul could have readily obtained by other means. For example, who was the FBI agent who signed off on the search warrant? Well, he knows because the FBI agent was there in person. And so that was kind of a clue. Article number 5, engagement of Kamak, the guy he hired to conduct investigation into a baseless complaint, issuing more than 30 grand jury subpoenas in an effort to benefit Nate Paul. Article 5 is looking pretty good. Termination of the whistleblowers remains the best charge, right? That it's like he terminated these guys and taking adverse action against them in violation of the law. So Article 6 looks pretty good. Article 7, misappropriation of public resources. Paxton directed the office to conduct a sham investigation of whistleblower complaints. We haven't really heard evidence about that. The settlement agreement from public funds, unclear at best. Article 9, employment of the mistress. We've heard no evidence about that, so that was out. Article 10, constitutional bribery. Article 11, abuse of judicial process has been suspended. Article 12, Article 13, Article 14 have been suspended. Or held in abeyance, to use the more proper language. Article 15, Paxton caused or made multiple false or misleading statements in a lengthy report. We really haven't heard testimony about that. Article 16, attempted conspiracy. Yeah, we got some evidence on that. Misappropriation of public resources. Dereliction of duty. Acting contrary to the public interest. Article 19 on fitness for office and Article 20 abuse of public trust, which are kind of your sort of end conclusions at the end. So I'd say the evidence is best for 1, 5, 6, and 16 for attempted conspiracy, and a lot of these other charges are questionable, or we've heard no evidence, and also they're desperately running out of time, and I don't think we're going to hear any evidence because they don't have any time. Because they just like, what clock? The clock is a phantom of my imagination. The clock is real, my friend. The clock owns us all. We are all the clock's biatch. But the prosecution doesn't seem to have realized that yet. And so I don't think we're going to get evidence as to some of these charges. So that's where we're sitting on that. So yeah, of course, all this should not be understood to say that we are, of course, done. We haven't heard from the defense at all or their witnesses, and at least they have some time, which leads to the possibly hilarious scenario where Ken Paxton will testify and there will be no time for cross, which would just be hilarious. That would be a oopsie. And that would be absolutely hilarious. Regardless of how this impeachment turns out, that is a lot of schadenfreude. You know, I literally don't have time to cross-examine the key witness. Would just be epic. Do we have a statement of time left for the prosecution? It can't be very much. It can't be very much. They've got to be down to like 2 hours or something. I don't know if we have an official statement, but they don't have any time. They've burned their clock. So, and they have not presented evidence as to some of these charges, in my humble opinion. So, not very efficient. And it's a self-own. It's a total self-own. It's an efficiency problem. They could have gotten what they got in out of all the witnesses and used 20% less time easily. If they had just been more efficient about it. At least 20% of the prosecution's case has been needless fluff. When you're on the clock, get to the point. I like the clock. As a legal theory. I think the clock is best. Make the attorneys actually, work under some constraint and, actually get to the point. I think the clock, I think the chess clock, I think justice by chess clock might be the greatest idea I've ever heard of in my life. If I become judge, the chess clock will guide us all. I'm telling you, the clock is bae. The clock kicks ass. I like clock. The fact that the prosecution's team doesn't seem to understand the magic of clock is decidedly, from my point of view as a judge, decidedly not my problem. It's like I told you in advance. I wasn't kidding. This isn't a surprise. I told you exactly. And you're like, okay, well, now I don't have any time. Yeah. We're going to have, some big chess clocks in the courtroom. We'll put them right on the damn wall. It'll be there in big things for everyone to see. They won't have to ask me how much time there are. They'll just be big right on the wall. No muss, no fuss. You'll know exactly how much time you have. And when you get to the end and be like, I want more time, I'll be like, what does the clock say? Does it say 0? Okay, the clock has answered your question. Don't ask the judge, ask the clock. Judge, can I have more time? I don't know. I'm not the right person to ask. Did you ask clock? Clock, can I have more time? I don't know. The clock says 0. It sounds like no. Sandy says, held in abeyance. When did that happen? It happened at the very beginning. Can I explain fully? Sure. So 4 of the charges have been held over. They're paused for some future time, maybe. I don't know really why, but that's where we are. So the Senate decided to hold 4 in abeyance. So they're in a pause state.
In session, the Honorable Governor and President of the Senate, Dan Patrick, now presiding.
There's a possibility we might do this impeachment thing all over again. They all relate to, by the way, the charges that Paxton is facing criminally, which has been facing for 8 years, as to securities fraud, principally. So, yeah.
Bailiff, please bring in the jury.
You guys, yeah. I used to do public speaking in Toastmasters. I haven't done it in a while, but when you're doing a competition speech, it's like, yeah, you get 5 to 7 and you get a 30-second grace. And they are not kidding. If your speech is 7:31, they will absolutely disqualify your ass. So you better make sure that speech falls within 7:30. 7 minutes, 30 seconds. 7:31, they will DQ your ass. They are not effing around.
Would our senator come up to lead us in prayer? Senator Flores, today.
Thank you, Mr. President. Members, let us pray. Heavenly Father, we come to you this morning, thankful to know the Holy Spirit surrounds us, for where 2 or more are gathered in your honor, you are present in our midst. Time and time again, you continue to love us as your imperfect children. Lord, I ask you to forgive us our failures and sins, and through your Son, we are truly forgiven and washed clean in your kingdom. Lord, we thank you for you, God alone, are the way, the truth, and the life everlasting. Father, we come to you this morning with beating hearts. May we not dismiss the gravity of our actions we have here today, and may we seek your wisdom, discernment, patience, and just understanding. Father, we ask you to clear and calm our minds to be ever present here, so we may have pure intent in our decision-making. Amen.
Thank you, Senator. You all may be seated. To both parties, there was the thought that we may have to meet this morning. Did you all work out whatever you all were going to work out on exhibits last night?
Your Honor, we're still working through some of those issues. We didn't get exhibits from them until this morning, and so we still have some questions that we're working through. I think what we've discussed is that we can address those at the first break, or at least that's what we're working towards.
All right, thank you. Members, the time clock, the House has 5 hours, 17 minutes, 2 seconds remaining.
Really?
With all time that we gave back yesterday added already into that. Respondent has 9 hours, 57 minutes, and 27 seconds remaining. I want to remind the jurors that no phones are to be used on the floor, even during breaks. There may have been a little misunderstanding of that. If you're on a break and you need to make a call,
5 hours?
you need to leave the chamber.
That seems odd, but okay.
Behind the brass rail or in the court setting during the time we're in session.
How's a radio host show the judge? Because the radio show host is the lieutenant governor of the state. And it's being tried in the Senate. So he's the president of the Senate. That's how. So, you know.
All right.
Yeah, you know, your judge is a radio show host. So that's what we're doing.
The bailiff will bring a lawyer also. Yes,
With no legal training, you are correct. Yes.
please come up. Yeah.
Yeah, that means they use 4 hours. No way. I'm kind of with you. Incidentally, by the way, just FYI, we will have to end tomorrow at around 6:15 p.m. So we may miss the end of the day, which, yeah. How do they have 5 hours left? How's that possible? How do they have 5 hours left? How's that possible? Michael Santon says saying no legal training is an appeal to authority bias. It's really not. It's an appeal to being, you know, qualified to reach a legal conclusion by this statement. You know, if you don't have legal training, it's kind of hard to make proper legal conclusions. So that's not an appeal to authority. It's just you literally don't have the qualification for the job. You know, if you've never gone to med school, you might not be a very good doctor. So, you know, unless you learned on the job, which also raises its own problems. Yeah. How do they have 5 hours left? Did they put words in the mouth of clock? I'm offended. I'm offended. I'm offended on behalf of clock. Lincoln was an attorney, but I don't know what his education to become an attorney was at the time. Although, of course, at the time, there was more of an apprenticeship thing than legal school. So he might have apprenticed to become a lawyer, which was more common at the time. But still, like, he would have had legal training. So... Dan Patrick has a judge helping him, but she's an appeal court judge, not a trial judge. I'm sure she's fine. She's on the Fifth Circuit Court of Appeals. I'm sure she'll be fine. Yeah. Abraham Lincoln was also a pro wrestler, which is kind of a fun fact. Pro wrestler president. So. I don't know whether or not he was a vampire hunter. I've seen the movie, but I think that might be apocryphal. I don't think that's necessarily based on reality. If the circuit's been making some pretty crazy rulings, less so from my point of view, but that's fair. Pretty sure it was meant as a joke. I got it. I got the joke. Did the fact that I deadpanned answer not imply that I didn't get the joke? I got the joke. I just chose to deadpan answer it. Was it funny? You do realize I'm not a complete idiot, right? How's this case looking? I'm only able to pop in for bits. Is this a witch hunt? Or did I vote for the wrong man? There is a fair amount of evidence against Ken Paxton. There is, of course, an underlying question of fact as to why he did the things, but that he did the things doesn't seem to really be in dispute. Why he did the things is more in dispute. What was his aim and purpose behind the things, and what was going on. So there is evidence.
So you're clear on the rules and the agreement that we made with both parties before the trial that witnesses must be given 24-hour notice. And Ms. Olson was put on the list at 3:53 yesterday, so she would not be eligible until 3:53 today. And the same thing applies. Either side can put on a witness on their list up till noon that they can call in the morning the next morning, but after that, it's when they put them on the list. The defense has some on the list for later this afternoon, for example, that they can't call up until then if they choose to. So with that, Mr. DeGuerin?
Yes, Your Honor. Ms. Epley will call Ray Chester as the next witness.
Bailiff will bring in Ray Chester. And members, the reason for that was so each side can prepare for a witness in time when they appear.
Fair notice to the other side? Wow. What a concept. All right. Yeah, I definitely call clock to the stand right about now. Is it really 5 hours clock? Really? Serious? Oh, no, clock. Are you telling us the truth, the whole truth, and nothing but the truth? Okay, I admit it. They manipulated my hands. I didn't want to. They wound me back. They wound me back.
Mr. Chester, if you'll raise your right hand, I do solemnly swear or affirm that the evidence I give upon this Senate of the Texas impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. I do. Please have a seat. And as we encourage everyone...
Oh, this would be direct, not cross, by the way, so I have to correct that title.
As close to the microphone as you can be when you speak. Thank you. You may proceed, Ms. Epley.
Thank you, Mr. President. Please introduce yourself to the ladies and gentlemen of the Senate.
My name is Ray Chester.
And Mr. Chester, what do you do for a living?
I'm an attorney in private practice. I'm a partner at the Austin law firm of McGinnis Lockridge.
Are you the same Ray Chester that we might have heard connected to the Mitty Foundation and issues with the Office of the Attorney General in 2020?
Yes, I've represented the Mitty Foundation since 2016.
And where is the Mitty Foundation located?
Currently, they're mainly located in Brownsville.
Okay. What does the Mitty Foundation do?
Currently, well, they were started by Roy Mitty, who grew up dirt poor in Brownsville and self-made man. It's actually a family foundation. It's not a public charity. They don't accept public donations. And for many years, they mainly provided scholarships to needy students. And in recent years, they've shifted their focus back to Roy's hometown of Brownsville, and they've developed the Mitty Cultural District in Brownsville.
Who runs the Mitty Foundation now?
Roy's grandson, R.J. Mitty. R.J. was born with cerebral palsy. You may know him as Walt Jr. from the TV show Breaking Bad. He's an accomplished actor. More importantly, he's an international spokesperson on disabilities and the rights of the disabled.
Well, I didn't know Breaking Bad was making an appearance in this story, but okay.
United Cerebral Palsy Foundation, and he gives motivational speeches to students on anti-bullying and overcoming disabilities.
Thank you, sir. The Mitty Foundation has been disparaged somewhat over the last couple of days in regards to prior management. How long ago were those issues?
They were in the 2000s, and the Mitty Foundation received a clean bill of health in 2011 and has been squeaky clean ever since.
Has management changed since that date?
Yes, the problems were Roy's son and RJ's dad.
Let me interrupt you, Mr. Chester. I'm sorry. I'm on a time clock, and I expect they might ask you those questions.
Okay.
What I'm trying to determine is there any rational basis, given the change of management?
I didn't realize the Mitty Foundation was Walt Jr. from Breaking Bad.
To justify intervention.
Okay.
Objection, Mr. President, calls for speculation and improper opinion by this witness without a predicate.
Overruled.
If they call the actor to the stand, I'm going to lose my shit.
Let me turn your attention quickly then to the settlement from World Class Holdings that we've heard in detail. What was that settlement value?
We settled in July of 2019 for $10.5 million.
After the breach of contract, what did the Office of the Attorney General push you to settle for at mediation?
Objection, hearsay.
This is what the Attorney General did.
Your Honor, if I may, he was present at the interactions. It's an operative fact, and it's already in the record. There is no harm from the hearsay.
I ruled.
Okay.
I do like that answer.
Mr. President, to be clear, because this may come up again, all these conversations would be privileged under Texas Rule of Evidence 408 as settlement discussions as well.
Mr. Chester, would you or the Mitty Foundation have an opinion as to whether or not you're interested in waiving that privilege?
We are willing to waive that privilege.
In that case, what would the result have been of you agreeing to settle at the mediation with Darren McCarty?
Objection calls for speculation and hearsay.
Overruled.
We would have received pennies on the dollar.
Do you have an approximate value, or do you recall the number that you were pushed to accept?
The only firm offer was...
Objection, Mr. President. Hearsay.
Your Honor, it's an admission by party opponent. It was an action on behalf of Ken Paxton by the Office of the Attorney General, and it's integral to the facts of this case.
And there is no evidence of that. None.
The evidence comes from the witness, as it always does in trial.
Stop for a moment.
Yeah, it's the Attorney General's agents. So, acting in the scope of their role, so...
Let me do it this way, since relevant facts are already in the record for the Senate to consider. What is the end result, considering that you were able to proceed with litigation?
We are poised to wrap up the litigation. The partnership properties are under contract. Mitty stands to receive approximately $23 million.
And when you say stands to receive, is that up to whether or not Nate Paul or World Class Holdings chooses to pay you?
No, fortunately, we're not depending on that because that would be fruitless. We will be paid out of the sales proceeds.
So the $23 million will come out of the sale of the property itself without any decision-making on the part of Nate Paul or World Class Holdings?
Correct.
Is that a delta of almost $18 million in loss if you had taken prior deals?
Then leading.
Sustain.
What is the difference between those net values and where you ended up?
It's going to be about $17 million more than we were offered when the Attorney General was involved.
Thank you. Pass the witness.
Wow, quick to the point. Well, I didn't know that was possible. Wow. They got done with the whole witness in like 5 minutes. Did someone teach them about clock? Wow. Dude.
Mr. Chester, how much money did your client, the Mitty Foundation, invest with Nate Paul?
$3 million. Well, in these two projects, $3 million. There were some other projects as well.
Okay, but the projects that are at issue in the litigation we are here to talk about, the Mitty Foundation invested $3 million in charitable funds with Nate Paul, correct?
With family foundation funds, yes.
Yes, and when we say family foundation funds, those are funds that were committed by the family to the charity, true?
Yes.
Okay, and of those $3 million that were invested in this program with Nate Paul, which is, it's really a private equity real estate deal, right?
It's a limited partnership.
Yeah, which we generally refer to as a private equity deal, right?
There's a slight nuance difference, but it's similar.
Yeah, it's very similar. You're in business litigation, correct?
Yes.
You've been in business litigation a long time, right?
Yes.
How many years?
Well, I've focused on commercial litigation about the last 10 years. Before that, I did other things.
Okay. I just want to make sure that I can harmonize this for everybody. The Mitty Foundation invested $3 million with Nate Paul, and they're going to get $23 million back, right?
Right. We invested in 2010, 2011. Yes, sir.
Right. So who at the charity made the decision to invest charitable funds in a private equity real estate deal?
That would have been the board at the time.
And how many years did you say you've been doing business litigation?
You know, full-time, 10, off and on, my whole career.
Okay. Have you ever seen a charity make a $3 million investment in a private equity real estate deal before this?
Yes, sir.
Yeah. Do you remember the circumstance?
No, and I don't think it was exactly $3 million, but I just don't think it's an uncommon occurrence. They actually had 4 successful investments with Mr. Paul before his troubles arose.
I want to make sure that the jury heard that because I don't think I heard it very clearly. What did you say?
I said that they had a total of 6 investments, and the first 3 they made money on. The 4th one, he tried to swindle them. They still made money, and now there's 2 remaining.
Okay. But the one that you're saying Nate Paul tried to swindle them on, that's the one they're going to make $23 million. They're going to make, I'm sorry, you're shaking your head at me.
I may have misled you. The last 2 are the ones that they're going to make $23 million on. The 4th one was the one he tried to swindle them on.
Okay. That has nothing to do with the litigation.
Not really, no.
So the Mitty Foundations have been the Mitty Foundation's been a long-time investor with Nate Paul before having anything to do with the Attorney General. Is that right?
Yes.
Okay.
Yeah. Okay.
During the pendency of your representation, has leadership of the Mitty Foundation changed?
Yes.
And do you know a man named Dilum Chandrasoma?
I do.
And he is no longer with the foundation, is that right?
That's right.
And what were the circumstances, Mr. Chester, under which he exited that foundation?
He was arrested in 2019 for a domestic incident. The charges were later dropped, but we immediately asked him to resign.
He was accused of beating his wife and son, I think?
I don't know the details, but it was some type of domestic violence incident.
Something like that?
Charges were dropped, though.
I see. On an affidavit of non-prosecution, I'm sure, by his family, true?
I don't know, but we asked him to retire nonetheless.
Now, by the time the AG's office intervened in your pending action, your client had spent almost $800,000 or so with you, true?
Right. Most of that after.
Objection, Your Honor, relevance.
Overruled.
Right, most of that after Mr. Paul defaulted on the settlement, yes.
Okay, so just to be clear, your law firm charged, and I want to make sure that we have this in order. These are charitable funds that the foundation is paying you with, right?
Yes.
And you charge that client almost $800,000, right?
At reduced
Objection,
rate,
Your Honor.
since it was a charity.
I'm sorry, objection, Your Honor, relevance. If I could take him on a brief voir dire, I would be able to establish why attorney's fees are irrelevant to any conversation here.
Mr. President, we don't voir dire on relevance. The clear relevance of this is how the Mitty Foundation uses its money. It's at issue on direct. It's at issue now.
It is also recuperated.
Overruled.
Okay. So you were charging, I believe, $450 an hour to the foundation, right?
At that time, yes.
And that's well below your rack rate of $625 at the time, right?
Might have been $715 at the time, but yes, it was well below my normal rate.
And what's your rate now?
My standard rate is $715.
Okay. And you had already, by the point the OAG's office intervened in the dispute, you had already gone through a AAA arbitration, correct?
We were just getting going in a AAA arbitration.
I'm sorry, you and I are both business litigators, so this may be a little inside baseball, but AAA is American Arbitration Association, yes?
Right.
Yes, and so what had happened was you, on behalf of your client, filed a AAA proceeding to arbitrate a dispute with Nate Paul's businesses, right?
Actually, Nate Paul filed it, but yes.
But you had counterclaims, right?
Yes, we did.
And you prevailed, right?
We won, yes.
Yeah, but to be fair, you never gave the Attorney General's office notice of that proceeding as is required by law, true?
I believe the law requires notice of a lawsuit, and there was a lawsuit, and I was a little late giving them notice.
And you were probably close to a year late, right? Something like that?
Yes. However, the lawsuit was dormant for most of that year, but yes.
I'm not being accusatory. You just didn't know.
I didn't know.
Yeah.
The judge told me she was the former head of charitable trust, and she said, have you given the AG's office notice? I'm like, oh my God, and so I sent it the next day.
Of course, of course. So the pendency of the intervention by the Attorney General's office, it lasted a total of about 3 months, right?
Approximately.
Okay. Between us business litigators, 3 months is nothing in the life of business litigation, is it?
Well, this has been going on 5 years, so I recognize your point, but those were some crucial 3 months that cost us a lot of time and money.
Well, I want to talk about what happened during that period of time. So at some point, the Office of the Attorney General intervened, and that's, well, why don't we just go ahead and pull it out so everybody has it in the record.
I don't know what the point of any of this is.
This Exhibit AG 156. May I approach the witness, Your Honor?
I don't understand the point of any of this. All right. Isn't it true that you invested with them in the past?
Okay with the microphone?
Sure. Isn't it true that you filed an arbitrary? Yeah. What does it matter? I don't know. Yeah.
If you would, Mr. Arroyo, Exhibit AG 156. Thank you. And Mr. Chester, just tell the jury, when was this filed?
June 8th of 2020, 10 days after the stay was lifted.
Okay. Now I'm going to hand you a really big document.
Oh, my Lord.
I know. That's what I said, too. Now, this is the transcript of the hearing on your motion for sanctions. Okay?
Okay. Which one? We had about 8 of those.
You got a bunch of them, right? This one is from June 25, 2020, 17 days after the AG's office intervened.
Okay.
It's marked as AG Exhibit 13.
Ugh.
Thank you. Thank you.
Mr. Little, are you entering this into evidence?
I am, Mr. President. This is AG Exhibit 13. We move for admission.
No objection.
I was glad you say you didn't want to read it. We'd have been here for a while. No objection. Enter
Now,
0013 and evidence.
Thank you. Now, Mr. Chester, as a litigator, if the AG's office were going to intervene to help Nate Paul, your motion for sanctions and the receiver's motion for contempt and sanctions probably a pretty good time to do it, huh?
I couldn't comment on that.
Well, why don't you hold,
I'm not sure what you mean.
this is 433 pages. Why don't you just hold this booger up for the jury, if you would? Just hold it up for them so they can see it.
It's the transcript's only about a first third. The rest of it's exhibits. But
Yes, and this was a lengthy hearing. You argued, you introduced evidence, offered and admitted it, true?
yes, sir. I did my best.
It looks like you did. It looks like you did a very good job. You won this hearing, right?
I believe so. Yes.
Did the Office of the Attorney General fight for Nate Paul on any of it?
Not in this hearing.
They didn't try to keep him out of contempt. They didn't try to keep him out of discovery sanctions, did they?
Not in this hearing.
Yeah, here's a whole bunch of times the Attorney General's office didn't try to interfere with us.
Toward the end of June, so maybe about 3 weeks, or
Yeah,
so,
and-
2 to 3 weeks after the intervention, you were contacted about doing a mediation.
It's like mostly peaceful protest. Yeah, most of the time, the Attorney General's office isn't doing anything.
Daily about that from the moment the intervention was filed.
And to be clear for the jury who may or may not be civil litigators, I know some of them are, mediation is just a formal settlement conference presided over by a mediator, yes?
Right. This would have been our third one in this case.
Yes, and so what the AG's office was proposing was to have the parties, the Mitty Foundation and the Nate Paul entities, come together with the mediator to see if they could reach a settlement, true?
Yes, it would have been the third mediation and we'd already settled the case. But yes, sir, you're correct.
Okay, and to be clear, you could not settle the case, correct?
Explain, please.
Yeah, you couldn't settle the case, and one of the reasons was your other SEC attorneys let me try to back into this a little bit differently. How many lawyers do you have at McGinnis Lockridge?
70 or so.
Do you have securities enforcement attorneys?
Securities enforcement attorneys. No, we do not.
Okay. Do you have securities litigators at your firm?
You're looking at him.
I'm looking at him?
Yes, sir.
You're a man of many talents, aren't you? So
I know a little bit about everything and not a lot about anything.
That's great. Speaks very highly of you. So, Mr. Chester, at this point in time, one of the concerns that you had was back in 2019 when Nate Paul was raided, the SEC had someone involved in that raid, true?
That was, yes.
And one of your concerns about settling the case by the Mitty Foundation against Nate Paul and his entities was that if the SEC sued Nate Paul and got a receiver appointed, that receiver might try to disgorge the settlement. Yes?
We call that clawback, and that was a concern.
Yes, and it was a concern that you had, and a very good reason not to settle. True?
And I expressed that to the Attorney General's office on multiple occasions. Yes, sir.
To whom? At the Attorney General?
Josh Godby and Darren McCarty.
And Darren McCarty was, well, you used a word to describe him in your testimony before the House, right?
That was
What word?
that was indiscreet.
What word did you use to describe him?
It begins with an A and it ends with an E and has 7 letters.
Okay. But you don't have any evidence that Ken Paxton ordered him to be an a-hole to you, do you?
Other than what Mr. McCarty told me.
Oh, other than what Mr. McCarty told you, no?
Right.
Okay. To be clear, maybe Darren McCarty was just born that way, right?
Or maybe he was just doing what he was told.
But you don't know either way, do you?
I don't know either way.
I didn't think so.
Maybe he's born with it. Maybe it's Maybelline.
At some point in time, bankruptcy entered the discussion in this litigation, true?
Mr. Paul filed bankruptcy 5 minutes before the deposition of his vice president of accounting. Yes, sir.
Okay, and just tell the ladies and gentlemen of the jury, what happens when you file a bankruptcy petition on behalf of an entity in litigation?
There's an automatic stay in all litigation involving that entity.
Okay, I'm going to approach you with what has been marked as Exhibit AG 212. And while I'm up there, I'm going to give you AG 41-2 to save time, okay?
Okay.
Well, at least we're getting some entertainment this morning. CG says you think that Paxton might be better covering it up. I tell you what, anyone can get complacent. You know, complacency happens to people big and small. You'd be surprised.
41's been pre.
You know, they're riding high. They think no harm can come to them.
Thank you, Mr. President.
212.
Especially white collar.
No, Your Honor. Like most exhibits, these match things we would produce.
Especially white collar.
Arroyo, if
You know, people tend to get lazier, more bold, and more complacent, and bam. You know? So, yeah, it happens. It happens a lot.
Is a letter from you, true?
Yes, sir.
Okay, and you're writing to Elizabeth Dykeman. Who's Elizabeth Dykeman?
She was a court administrator for one of the judges in Travis County District Court.
Okay, and you're notifying her of removing a briefing deadline, I guess, as a result of a bankruptcy filing. Is that right?
Yes, as we discussed, when the automatic stay kicks in, then everything stops, but the judges don't necessarily know that, so it's customary to notify them.
Okay, so I just want to be clear. For one of the 3 months that the AG was intervened in this lawsuit, it was subject to the automatic stay, right?
Right, although we were litigating like crazy in bankruptcy court.
Yeah, but AG wasn't part of that, true?
I don't believe so.
They were a notice party, but they weren't part of the litigation in bankruptcy court, true?
I don't believe they appeared in bankruptcy court.
Okay, so to be fair, you're litigating with this guy on behalf of the Mitty Foundation all over the place. AAA, State District Court, multiple lawsuits, bankruptcy court.
8 appeals.
8 appeals. And all that's with charitable money, right?
Yes, sir.
Okay.
Trying to get our charitable money back. Yes, sir.
And I believe you. And it sounds like you're going to get over 7 times the initial capital outlay back, right?
Long, hard fight, but yes, sir.
Okay. And to be clear for the ladies and gentlemen of the jury, in the previous 2 months before that bankruptcy filing by Nate Paul's entity in this litigation, AG's office was trying to foster a settlement between the parties, true?
They were trying to force a settlement on us.
When you say force, they can't force you to do anything, can they?
They were applying pressure. They weren't successful, but they tried.
They couldn't force you to do anything, could they?
I'll stand by my previous answer. They were trying, but they could not force us.
I appreciate your answer, but I need an answer to my question.
Okay.
The Office of the Attorney General could not force you to settle anything, true?
No, just pressure us.
No further questions.
Yeah, okay.
No, Mr. President, thank you.
Count 1 continues to look pretty good.
Excusing the witness?
Yes.
Wow. Look, we got done with the entire witness direct and cross in like under a half hour, man. I didn't know that was possible.
The House calls Andrew Wicker.
Bailiff, bring in Andrew Wicker.
MD says, has anything illegally been proven yet? Well, that's sort of a matter of judgment in the end about whether or not you think it's been proven. That's a question of fact, whether or not you think it's been proven. So all I can really say as a matter of truth, all I can really say as a matter of objective reality is that there is evidence that supports the proposition. Sort of the end conclusion is
Upon this
a matter as a question of fact.
of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please be seated.
There will not be legally bindings of fact by this jury. It will be done on this channel.
Please state
I
your
guarantee you that.
Andrew James Wicker.
name. Mr. Wicker, it's a large room. Yeah.
Okay. Andrew James Wicker.
Thank you. I appreciate it. Tell us a little bit about your background. Where did you grow up? Where did you go to school?
I went to school at Prestonwood Christian Academy. That's where I graduated from high school. I grew up in Prosper, Texas, a little town north of Frisco, Texas, in North Dallas.
Let me pause you for a moment.
Okay.
Can y'all hear him well enough? Okay.
No? Okay, how about this?
Thank you, much better.
All right.
Please go ahead.
My name is Andrew James Wicker. I grew up in Prosper, Texas. I grew up going to school at Prestonwood Christian Academy, which is where I graduated from high school. I then continued on to go to SMU for undergrad, and then I went on to a graduate degree at Georgetown University.
Okay. Can you tell us a little bit about what activities you were involved in college?
I like Georgetown as a school.
While getting your master's.
In terms of my involvement in college, my first job was working for Don Huffines on his Senate campaign. And then I continued on to later be involved with founding the Young Americans for Freedom chapter at SMU, where I served as vice president.
Matova, I take extreme exception to that. That's putting words in my mouth, and you know it's putting words in my mouth, and I don't like that very much. Am I saying if the jury finds guilt, he can be immediately sentenced by a federal judge for his crimes? Did I say anything that even remotely resembles that? No. So don't put words in my mouth.
To Georgetown and landed in DC for my graduation, and then I went to work for General Paxton.
Okay. Do you recall approximately what time or the date that you went to work for Ken Paxton?
My employment with the OAG started September of 2019.
How did you originally meet Mr. Paxton?
I had met General Paxton previously, both as my state senator, but also as the Attorney General at various Lincoln Reagan Day dinners. In terms of my employment and the opportunity to start working for him, I met him through Mark Rylander, who was a previous associate in North Texas in terms of my community. And I was recommended for the position by Mark Rylander to General Paxton. And that's whenever I met him at the Marriott Marquis in DC, and I was hired.
Okay. If Jeff Mateer was the first assistant, did Mr. Rylander have a nickname as well?
He was known commonly as the first friend.
Okay. And through that connection, you end up working at the Office of the Attorney General. In what role? What'd you do?
My title was executive aide to the Texas Attorney General, and then I was also on the campaign staff as well.
And what does an executive aide do?
My responsibilities expanded and contracted as I also had to assume scheduling responsibilities. We had 2 schedulers during my time there. Whenever we did not have a scheduler, I assumed those responsibilities, but my standard job responsibilities during whenever I was performing the functions as an executive aide was to ensure that the general was going to his schedule on time, that he was prepared for those appointments, and that he had all necessary documents and context to the discussions that he was having for that day.
That sounds like a great deal of access to the Attorney General. Is that fair?
Yes.
Approximately how much time did you spend with each other in any given day?
At least 8 hours, normally closer to probably 10.
And was that just weekdays or weekends as well?
That would include weekends.
How often was Attorney General Ken Paxton in Austin in 2020?
This was during COVID, so after probably the first 3 or 4 weeks of COVID setting in, he spent the majority of his time in Austin, starting in probably about April-May timeframe through the remainder of 2020.
And where was Senator Angela Paxton?
She regularly split her time both between their home in McKinney and in Austin.
What was your relationship with the Paxtons, individually and as a couple?
Individually, I would call General Paxton as a friend. I spent a great deal of time with him. He and I bonded over a good number of activities, such as watching football, sometimes talking politics, but just talking life. With Senator Paxton, I would say that she was nothing but loving and caring. I think she also understood that the demands of the job kept me away from my family, so in many ways, she was kind and understanding in the way that a mother would be normally. As a couple, I would say that they were incredibly welcoming and caring to me, and always inclusive.
So fair to say there's no animosity or bad blood between you and the Paxtons?
Not from me, no.
Are you part of some vast conspiracy to harm them?
No.
Are you in league with TLR or the Bushes?
No.
Are you here to tell the truth?
Yes.
I'm going to turn your attention to Nate Paul. Are you familiar with that name?
Yes.
How so?
During 2020, I was introduced to Nate Paul, and there were a number of activities and discussions that revolved around Nate Paul throughout 2020.
Can you tell me the first time you remember hearing of Nate Paul or meeting him?
The first time I remember meeting Nate Paul would have been February or March of 2020. General Paxton and I met him for lunch at Terry Black's barbecue.
Was it just the three of you?
I like Terry Black's.
And what was
Respect.
the topic of conversation?
Objection, hearsay.
I think Terry Black's is the best barbecue in Texas.
May I please respond? Anything from Ken Paxton is an admission by party opponent. Nate Paul is very clearly tied to a conspiracy, at least in terms of the evidence before this Senate, and Drew Wicker is available for cross-examination. None of that evidence is hearsay.
Again, Your Honor, the question she asked, she did not specify who was talking. Anything Nate Paul may or may not have said would be hearsay.
In the course of getting to know Nate Paul and Ken Paxton as a friendship, well, let me do this differently. How are the interactions between Nate Paul and Ken Paxton?
I'm sorry, can you state this question again?
Yes, sir. What was the relationship like between Nate Paul and Ken Paxton?
Objection, Your Honor. Speculation. He can testify about what he saw and maybe what he heard from Ken Paxton, but that's the extent of it.
It's foundational evidence, Your Honor. He can testify to his rational perception of the facts.
Sustained.
Did you see the two of these men?
I like this attorney.
Yes.
I like the way that she responds to objections.
In terms of their demeanor.
A cordial relationship?
Did Mr. Paxton look to be under pressure to you?
No.
Now, I'm going to turn your attention to the second time you had lunch with them. Do you recall that?
Yes.
And where was that?
That was at Polvos, downtown in Austin.
Do you recall approximately when?
This would have been May, June timeframe.
Okay. And was anybody else present for that lunch?
Ryan Bangert.
Does Mr. Bangert work for Attorney General Ken Paxton at that point?
He did.
Is he there in his personal capacity or as part of his job duties?
He was asked by the general to attend as part of his job responsibilities.
And what was the topic of that conversation?
The Mitty Foundation.
Did anything change in regards to what Mr. Paul wanted between the first and the second lunch?
Objection, Your Honor. This calls for hearsay again.
Your Honor, if I may, I would really appreciate it if you would look at 801 E2D, specific to co-conspirator statements.
Your Honor, there's no evidence of any silly conspiracy. This is hearsay.
This entire trial has been about a conspiracy, Your Honor.
Sustained.
Who paid for lunch?
Nate Paul.
How did you perceive their demeanor and interactions with one another, hostile or friendly?
Between Nate Paul and Ken Paxton?
Yes, sir.
Friendly.
What about Ryan Bangert? How was his demeanor?
Inquisitive.
Did he seem to agree with what it is they wanted?
Objection, Your Honor. Speculation. We've already heard from Mr. Bangert.
That is exactly why it's
speculation.
relevant, Your Honor. He attacked the credibility of Mr. Bangert. So it is not only not hearsay because he's a representative working for Attorney General Ken Paxton who would have adopted a belief in or offered contrary information to. In addition to that, it's a consistent statement used to rehabilitate Ryan Bangert because of their attacks.
Your Honor, I'm sorry to belabor this, but Mr. Bangert testified, and to have this witness tell us what Mr. Bangert's attitude was about some lunch 3 or 4 years ago is just improper.
Time frame has nothing to do with exceptions to hearsay, Your Honor.
Overruled.
Thank you. Can you please tell me what Ryan Bangert was saying in response to this conversation?
Okay, Your Honor, now she changed the question. And
I'm
she didn't get
entitled to do that.
Let me finish my objection, please. Now she would, instead of the witness answering the last question, now she's asked a clearly hearsay question.
I went more specifically at it after the court's ruling, which I'm entitled to do.
She cannot ask this witness what Ryan Bangert said. She just can't do that, and that's what she just did.
Sustained.
Thank you, Your Honor. I'm going to turn your attention to the third lunch involving Nate Paul and Ken Paxton. Can you tell me when that was?
This would have been June, July timeframe.
Of 2020?
Yes, ma'am.
And who was present at that lunch?
General Paxton, myself, and Nate Paul.
What was the topic of conversation for this lunch?
The FBI raid on Nate Paul's home and office.
Specifically, access to the affidavit underlying that search warrant?
Objection leading. And again, Your Honor, I'm sorry to interrupt, but she's asking about what Nate Paul said at a lunch. That's improper, and that would be hearsay.
Your Honor, may we approach?
You may approach.
I like her. And it's like, she's like, I really want to press this issue because it's a statement from a co-conspirator. That's the whole allegation. It's like, yeah. It's like she wants to press the issue. But I appreciate that she's doing it by going to the bench, She's like, I know the rules. Here are the rules. I like the way that she asks the questions. I like the way that she cites the rules. The way that she's very sharp. She's on point. She's very professional in how she handles it. She's a good lawyer. I like her quite a lot. She's not deleterious either. Like, she's not wasting time. She's a lot more focused. It's worth the time for the objection. It's worth the time. Because it's a pretty big deal, right? Getting these statements from Nate Paul in is a pretty big deal, so it's worth the time. At least she's spending time doing something as opposed to wasting time, which we've seen so much from the prosecution. She's actually using time for, for a reason, for a just purpose, as opposed to just dicking around. Yeah, the clock may very well stop in the sidebar or not. Depends on the chair's discretion on such things, but she'd probably get a pause on the clock as well, too, because of the nature of the objection. It's not like routine. She's not like abusing the privilege, so she'll probably get the time back. But even if she was burning the time, it'd still be worth it. Melanie, if you really believe this whole thing is a waste of time, then to some degree, I'm not 100% sure why you're here. It's like we're trying to learn something, trying to do some legal education along the way. I mean, it's like trying to assess this from a legal framework. Yeah, so in the question about how you prove the conspiracy, it's a threshold question for the...
I am sorry to interrupt, but I would like to ask for some time back and to stop the clock, please.
The clock stopped when you came up.
Thank you.
Yeah, fair enough. Yeah, you have to like make the prima facie case. You don't have to obviously prove the conspiracy, but you have to make the prima facie case of the conspiracy. And, you know, the prima facie case has been made to my belief and understanding, so... We're just chilling along here, having some fun. So, yeah, to quote one case under the federal rules, you have to show by preponderance of the evidence the conspiracy existed and the statements were in furtherance of the conspiracy before they can be admitted. So I'm not sure what Texas's specific version of that is, but I'll see if I can find some Texas-specific law on points.
We will sustain the objection.
May I proceed? Outside of those 3 lunches in which you ate with Nate Paul and Ken Paxton, did you have occasion to be around them on other times, other occasions?
Yes.
And what kind of things would you do together? Where would you see them together?
There were 2 types of instances. The first was continued lunches, usually at Polvos. The second was meeting at Nate Paul's place of business. And I was not part of those discussions whenever those did occur.
So to make sure that I understand, there would be times you were at lunch but not seated at the table and eating with them.
That's correct.
How many times did that occur?
Dozen and a half.
And what about trips to Nate Paul's business? How many times do you recall that happening?
At least a half dozen.
Were you ever at Nate Paul's home?
No.
And did you ever see Nate Paul join Ken Paxton at the office?
Only once.
Okay, we'll come back to that in a moment. Your Honor, at this time, the House offers House Exhibit 704, which is a public record. It is already on file, and there's a business records affidavit attached that has been on file with the court and defense for over 14 days.
Any objection once you read that?
She sounds a little frustrated, but she is frustrated, but I still think she's handling it very professionally. And I think, she's also very frustrated because I think that she has a better legal end, and she's frustrated because she's getting the wrong ruling from the judge. That can be very frustrating.
Your Honor, there's a facial problem on this exhibit. It claims an affidavit.
Thank you, Tina.
12 pages of records, but apparently there's 23.
For the super chat. Appreciate your contribution.
That matters, but the affidavit is improper and obviously inaccurate, unless somebody wants to correct me.
Your Honor, it's a record of the Texas Department of Public Safety, and pursuant to the rules related to public records, it would be incumbent upon Mr. Busby to establish why he thinks the records would be inaccurate. Also, the page count is likely attributable to the fact that photographs were enlarged and attached.
Again, Your Honor, she's the proponent of this document. It says it's 12 pages. It's not 12 pages. I mean, that right there gives us some element of maybe it's not trustworthy, and she's the proponent. She needs to show us why the affidavit doesn't match the documents attached. That's her job.
Your Honor, I'm confident in my response as it exists, but let me speak to my co-counsel out of a moment of respect.
That's an interesting way to go about it. See what my co-counsel has to say on the issue. I like the way she does that. That's very...
Give the court a copy of what I'm looking at.
I would also add that at the conclusion of each of the records is a notification that it's a certified copy. It comes in 3 different exceptions to hearsay: business record, public record, and it's a certified copy. Additionally, I emphasize that the Attorney General works for the state of Texas, and these are state of Texas records. It's intellectually dishonest for him to fight them.
Ooh, wouldn't necessarily add that last part, but okay. She's too snarky? No such thing, my friend. No such thing. We appreciate snarky over here. More snark. Not snarky enough.
And we returned about 10 minutes between the last 2 sections of this. It's an excellent defense strategy, but it's slowing us down since we agreed to all of their exhibits, and they would not for hours.
Your Honor, I'm sorry. This is important. First off, I've been called intellectually dishonest because I look at an affidavit that says 12 pages and it's 23. And now that we're playing games because they're offering an exhibit that's clearly not what they claim it is. So I'm just making my objections, and that's all I'm doing.
Yes. You stipulated it was 12, it's 23.
Yep.
So I am going to overrule the objection because there are 5 large photographs, may account for it, and it is a government document. But I'm not giving you back the time because if you had explained this up front, we wouldn't be having this issue.
That seems fair, Mr. President. I'll go faster.
Overruled. Here's your document back.
Stacy, would you turn to, don't publish it yet, but
704 is admitted into evidence.
turn to the picture we discussed. If we were to show you a picture of Nate Paul, would you be able to identify him?
Yes.
And are you going to feel like I've led you, or if I show you the wrong picture, will you correct it?
Yes.
Yes, you'll correct me?
Yes, I will.
Thank you, sir. Permission to publish.
Yes.
Who do you see on the screen before you?
That is Nate Paul.
And is this the same person that was having lunch with Ken Paxton on those occasions and whose office that you visited?
It was.
And is this the same person who is currently facing charges in the federal courts?
Objection. hearsay, and relevance.
Sustained.
Is this the same person who was discussing the MIDI Foundation in front of you?
Objection, hearsay. We've already discussed this. This is hearsay.
He was having the conversation with Ken Paxton, who's a party opponent, Your Honor. And again, I would direct you to 801.
Overruled.
Thank you. Is this the same person who was discussing MIDI with you and Ken Paxton?
Yes.
The same person who discussed...
Mambo says she's emotional, nasty, and angry. Disagree.
Was he making...
Disagree sharply.
Upon the office?
Objection.
I find her professional. She is slightly tilted because she is frustrated because the judge is giving some bad rulings.
To do.
But I do not find her emotional, nasty, or angry. Strong disagree.
Is this the same person who was talking to Nate Paul and Ken Paxton about MIDI?
Yes.
And what kind of things was he asking the office to do?
Objection, assumes facts not in evidence. No one's established he was asking for anything. Hearsay.
What was he asking of the office?
Again, Your Honor, she just asked the exact same question. Hearsay and assumes facts not in evidence.
I understand why he doesn't want this in, Your Honor, but can we stop the clock again?
Also, she is under a little time pressure. That's not her fault. So she's probably frustrated by her own side's incompetence because she's clearly a better lawyer, at least at this point, than some of her co-counsel.
Objection, and both sides need to stop the ongoing speaking objections.
Yes, Your Honor. May I get a clarification? A moment ago it was overruled and then sustained. Is Nate Paul going to be considered a co-conspirator for the purpose of this line of questioning or not?
Yeah, she's great. Maybe a little bit tilted, but she's handling it very professionally, in my opinion. So sharp disagree.
Your Honor, before you, if I could, a conspiracy requires an agreement. Can I take the witness on voir dire to establish there's never an agreement? A conspiracy at its heart requires an agreement between two parties and then acts in furtherance of the conspiracy. There's been no evidence whatsoever in this trial. There can be no evidence in this trial of any agreement between Nate Paul and Attorney General Paxton. This witness will confirm that. I would like to take him on voir dire to establish that, and we'll put an end to all this.
If I may clarify, it is not incumbent on the sponsoring witness to establish conspiracy. That is an obligation of the court or the presiding officer. This entire case has been about Nate Paul and Ken Paxton, and I understand why they don't want it in, but that goes to weight, not admissibility, and he can be crossed on these issues. This entire trial has been about Nate Paul and Ken Paxton.
Two questions, Your Honor, to establish with this young man that there was never an agreement. He never heard an agreement, no conspiracy, and we can quit talking about that. They can use this word all day long like they've been, but they cannot establish an agreement between Nate Paul and Ken Paxton.
I don't think that's true.
If I may.
They may have never heard the conversation that established the agreement. But the agreement can be established by the behavior of the parties, right? If you see two people doing, things in concert with each other, the conclusion that they agreed is a reasonable inference, right? You don't normally get it's not usual to be able to have the, literal words. The conspiracy can be proven through the behavior of the parties and the actions of the parties. Them acting in concert, and they're acting in concert is evidence of the agreement. So to say that you can't establish the conspiracy because they don't have the words just is wrong.
Ms. Epley, Mr. Busby, come up.
And I appreciate her fighting the point because, she's right. MD says they haven't established an agreement. It's all conjecture. It's inference, not exactly conjecture, right? It's the question of inference. It's the difference between an inference and a speculation, right? So you see people doing a bunch of things together. It's an inference that they're acting in concert. It's not exactly the same thing as speculation. It's not exactly the same thing as, conjecture. It's an inference that is, concludable. And then as to what level of proof you need to prove the hearsay for the purpose of to establish the conspiracy, I was trying to figure out exactly what Texas's standard is. I found a case.
We've already ruled on that issue. You may move forward.
Yes, Your Honor. Based on the ruling, I will proceed.
On the federal rules, you have to prove it by preponderance of the evidence, but I'm not sure what Texas's standard is.
Are you comfortable with that term? Do you know what I mean? In terms of MIDI, foreclosure, open records, and Brandon Kamek or the search warrant?
Yes.
Okay. Turning your attention to the open records request, who was in charge of the division during that relevant time period?
Ryan Vassar.
Turning correlation into causation?
You were asked to collect
a little bit.
Specific to an open record.
The question is, what is the root cause, right? Yeah, but yeah, the correlation is evidence of the causation.
And provide them to.
And did you do?
Yeah.
Yes.
What, if anything, do you recall about that package?
I recall that it was in a sealed manila envelope and it had a CD with it.
And when you say CD, I know common parlance, but can you explain specifically what you mean?
A compact disc to go into a computer to maintain digital files.
So something with structure to it that would hold additional data?
Yes.
Why do you remember it being there?
Because it was on the outside.
Where did you take that file?
General Paxton.
How long did it stay with General Paxton?
Randy, it's a lot more than that.
I did collect it
over the course of the witnesses. So, let's be intellectually honest about the thing.
After you collected the file, where did you return it to?
Ryan Vassar.
Do you recall during this time frame whether or not you had done any pickups or deliveries involving Nate Paul and Ken Paxton?
The deliveries that I made to Nate Paul took place in May and June.
Okay, and can you tell us about that?
There were 3 occurrences in which I met Nate Paul to pick up or deliver items. The first was to deliver a manila envelope. The second was to pick up the general's phone that he had left at Nate Paul's office. And
I'm still trying to find the exact standard in Texas, by the way, in case you're wondering what I'm reading.
Foundation to deliver to Ryan Bangert.
Now, you mentioned the delivery of a manila envelope. Do you recall whether that was substantially similar to the one that you had picked up from Ryan Vassar and delivered to Ken Paxton?
And this article makes the point, which is correct, that you don't even need to charge conspiracy.
The package was?
Just to offer them as conspiracy. So you don't even need to make the charge a conspiracy.
Similar to the way you explained it to us.
So that's true.
What is the smallest and largest it could have been?
The smallest that it could have been would have been about this.
I'm sorry, Drew. You want to object? He already said he doesn't remember. Now he's just speculating.
Overruled.
Please go ahead.
The way I explained it to the House impeachment managers was this size to this size.
And do you recall whether or not that package had any CDs attached to it?
I do not.
Do you know if it contained any?
No.
So would you be able to tell these senators that it was in any way substantially different than from what you received from Ryan Vassar and delivered to Ken Paxton?
No.
Okay. When we first spoke, do you recall approximately when that was?
May.
May?
May of this year.
And did you want to speak with us?
No.
What did you understand at the time, whether you were correct or incorrect? What did you understand we were doing?
My understanding was that there were questions about funding the settlement of the whistleblowers.
And when you arrived, was it subsequent to a subpoena?
It was.
Was that necessary in order to have you attend?
It was.
Did you arrive alone?
No.
Who were you with?
My attorney.
Who is your attorney?
John Evans.
Is he present here today?
He is.
And why did you retain Mr. Evans?
I retained Mr. Evans 3 years ago after the events that occurred in the fall of 2020. I retained Mr. Evans after being reached out to by the FBI, and after being offered counsel by the Office of the Attorney General, I chose to retain my own counsel that would look out for my own interests.
I want to make sure that I understand. At some point, the Office of the Attorney General offered to provide you an attorney?
Yes.
Are you under the impression you had done anything wrong?
No.
Did the Office of the Attorney General indicate whether or not they wanted you to speak to FBI?
They indicated that they would not like me to speak to the FBI.
And you said to protect...
In U.S. versus Nixon, the Chief Justice wrote, there must be substantial independent evidence of the conspiracy.
Attorney,
whatever the hell that means.
Attorney General would look out for the interest of that institution, but not for me.
And did you feel then that your motives or your interests were not aligned?
I didn't know that they were not aligned, but I wanted to make sure that they were aligned to my interests.
Okay. When we had you come in and speak to...
Some courts go so far as prima facie.
What was your...
So some courts go to prima facie evidence.
Were you forthcoming and happy to talk?
No.
Were you honest
so like
to the best of your ability?
the standard
Was that statement consistent with the testimony
you need to show the conspiracy to admit it is all over the map,
or at least the statement
is what I'm getting from a very quick read of the case law.
Yes, they were.
I saw you hesitate. Did you correct yourself on your own at some point during the conversation with us?
I did.
What was that about?
The correction was a question by the House team asking me whether or not I had delivered documents to Nate Paul. Over the course of that discussion, I was asked about it again, and I recalled that I had in fact done so. And
The Chief Justice wrote that in Nixon.
With my attorney and with other law enforcement officials that is consistent with my testimony from 3 years ago.
Thank you, sir. There was some...
Was that Berger at the time?
Or I think it was Mr. Busby talking about squeezing.
I could look it up.
Did you
but
feel squeezed?
No.
Did we threaten you at all?
No.
Did we lead you or give you the answers?
No.
So when you made that correction, why did you do it?
I did so because I remembered something and I had misrepresented my testimony whenever I provided an incorrect answer earlier, and so I sought to correct that.
Thank you, sir. I'm going to turn your attention then to the foreclosure and specifically...
I'm louder than court audio. I am when I talk. I am. Yes. The audio ducks when I talk so you can hear me.
Okay.
Do you recall any conversations?
I recall one conversation.
And what was that?
It was a conversation where I was in Ryan Bangert's office and overheard he and Ryan Bangert discussing...
Sorry, Drew. He who?
General Paxton and Ryan Bangert were discussing...
Check 1 2, check 1 2. My audio is a little bit louder in the courts. I can lower it down. Check 1 2, 1 2, 1 2.
Contact.
1 2. All right, that's a little bit more even.
Mr. Bangert responded that this individual had not been helpful in the matter that he had reached out about.
Let me pause you. Not helpful in what way? They just declined to assist?
I'm not completely aware, no.
Okay, go ahead.
The second part of that conversation was in which the general expressed a desire to make sure that grandmothers were not evicted from their homes, and that's where I learned about the foreclosure opinion.
Are you aware that there was a stay related to residential homes at the time?
At the time, I probably was.
So the foreclosure letter would have impacted commercial business, not residential?
Objection, leading, and speculation.
Sustained.
Getting the audio levels right is always fun and exciting over here in Uncivil Law. Is Jen a commental for attorney generals? Yes.
I'm going to turn your attention to...
It's kind of right in the name.
In the summer of...
Is general a common title for attorney general?
With that hotel at that time?
I was.
And why is that?
During the course of General Paxton's renovations at his home, that's where he was staying in the interim.
Okay, I'm going to come back to the renovations at his home, but help me understand, do you have any personal knowledge of Mr. Paxton being at the Omni in the summer of 2020?
I do.
How's that?
General Paxton called off his protective detail for the time that he was staying at the Omni Hotel. And as part of my job responsibilities, I picked him up and dropped him off each day to the Omni Hotel.
Did Mr. Paxton drop his security detail on few or many occasions in 2020?
It came in spurts.
Help me understand spurts. What would a frequency be?
There were times at which it was highly frequent and I was his primary means of transportation, and there were other times at which we utilized the protective detail.
And while we're on the topic, so that I can move a little faster, what about items being on a schedule? Was everything he did
Why Attorney General?
OAG or personally
I don't know.
reflected on a schedule?
Not sure what the origin of that one is.
Schedule supposed to contain the comings and goings of the Attorney General?
More generally, yes.
Why is that?
When it was originally created as a cabinet post, it was called the Secretary of Justice,
2-week outlook,
which was pretty cool.
so that they could understand where
Secretary of Justice.
who their POC was at that place and time. So
But then they renamed it Attorney General, so you'll have to do your own historical research on that one.
Mr. Paxton's plans were not contained on his schedule,
yes,
specifically related to Nate Paul.
yes,
How do you know that?
because I managed the schedule.
Did you have concerns about that at the time?
No,
At some point, did it become concerning enough to you for you to speak to a supervisor?
yes,
Who was your supervisor?
Blake Brickman.
And why would you go to Blake Brickman about such a concern?
I was receiving some new requests in terms of both transportation as well as documentation and scheduling, and I was trying to understand the best way to handle that with my boss, who is General Paxton.
I'm going to return.
It's from the French. That makes sense.
Were you there with your family?
Goddamn
Can you
French.
quickly tell this Senate why you were there?
There used to be a language or quasi-language called law French,
Come down
just to show you how much French
there was any sort of
infiltrated the law. They created a language specifically for it for a while there.
they were down there.
Goddamn French. Of course they're responsible.
General Paxton was also there at that time due to the renovations being conducted on his home, and they were staying down there, and I chose to stay with them for the time that they were at that hotel as well.
Did you have occasion to see Ken Paxton while you were there?
I did run into him, yes.
Can you please tell us about that?
My mom and sister had gone up to the hotel room. My father and I had run back to my apartment downtown. Upon returning to the Omnia Hotel and entering the lobby, we turned right.
Part of Texas was French for a while.
Elevators. We had
Fair enough, I suppose.
waiting on the elevators, and on the other side of the door, my father and I heard a lively discussion. Just to be clear, not adversarial, just lively. And whenever the doors opened, 2 individuals exited. One was General Paxton. He was in a...
Texas was heavily settled by Germans. That is very true as well.
Going to the gym.
The German influence in Texas is extremely well known for those of you who have any knowledge of history whatsoever. Yeah.
General Paxton walked out, shook my hand as well as my father.
Also of Mexico generally.
Told us he was going to work out.
The German influence in Mexico is also very pronounced,
Conversation could have included.
which might come as a surprise for some
If
people,
anything,
but
did you notice the
yeah.
dynamic between the two, if anything at all?
I couldn't overhear the conversation, but whenever they exited, she quickly exited the elevator, and that was the only time I really saw them interact in person.
Did that cause any concern for you or questions?
It did spur some questions.
And who would you have directed those questions to?
I reached out to Mark Rylander about that.
And why did you reach out to Mark Rylander?
German was
To the office of the Attorney General.
German was the number 2 language in the United States right up till World War I,
Had been
Objection, hearsay.
which led to that U.S. Supreme Court case. What's it called?
Whether true or not true on the part of Mr. Rylander, this might be something of interest to him.
Objection. Again, Your Honor, she's just trying to...
What is the
ask it a different way.
case?
This is based on hearsay.
School teacher wants to teach German. They
Do you
make
have
teaching
any reason
German
this might be of
illegal.
interest to him?
U.S. Supreme Court says the teacher has a right to teach German in school.
Seem to understand.
And the name of the case is, oh, come
Did you
on.
receive a photograph to confirm?
yes.
Now, I'm not going to show you the same photograph,
Shit.
but I'm going to show you a person. Would you be able to tell me if this was the person that you saw in the elevator?
Yes.
Damn it.
May I approach? So used to government work, I forget we have technology. Can I turn everyone's attention to 704? And Stacy, would you pull up the photograph, please?
Meyer sounds right. Meyer versus Nebraska.
Whether you know her name.
There you go. Meyer versus Nebraska. That's it.
For purposes of the record, the person being depicted in the photograph is Laura Olson, as established by her Texas driver's license. Thank you, Stacy. May I have 699?
Yeah, when you said Meyer, I remembered the name. Meyer versus Nebraska.
Next, Your Honor, the House offers Exhibit 699. It is a business record as established by the affidavit on the face. I'm confident that the page count will match this time, as there's no substantial photographs, and it has been on record for over 14 days. And it is being admitted by agreement, as I understand it.
Any objection?
No objection, Your Honor.
Admit exhibit.
And then, of course, remember that the Pennsylvania Dutch
Now, Mr. Wicker, I'm not
are
going to
German.
do this, but
right.
inside of
so the German influence in Pennsylvania,
explain where you have lived before,
where I was born,
where you're going to live now,
and where my German ancestry comes from, and the Pennsylvania Dutch.
I know that didn't make sense.
Germans are everywhere.
That application leases will establish your prior address as well as your current one.
Yes.
And is the name on that record the same as the driver's license, Laura Olson?
It is.
Is that the woman that you saw step off the elevator with Ken Paxton?
It is.
You mentioned home renovations. Do you remember why those renovations were occurring?
There were storms late spring that caused water damage to General Paxton's Austin home.
Okay. I don't want you to give the address, but could you give us the street name so that we're all familiar with the fact that we're speaking about the same thing?
Margarinita Crescent.
So you said spring. Do you recall what month the damage occurred in?
This probably would have occurred March, April timeframe.
Okay. And do you know where the damage was?
To the best of my recollection, it was confined to the master bedroom.
Why would you know that?
I met with the insurance adjuster multiple times at the request of General Paxton while he was out of town or in other meetings.
So there were occasions where you were authorized on his behalf to conduct personal business, for example, the adjustment of the insurance?
I was authorized to greet the insurance adjuster and show them the home.
Does that mean you would sometimes also receive records related to the home renovation?
I can only think of one occurrence in which that happened.
And what was that?
I received an invoice that I had been included on from the STEAM team.
And are you aware, as the adjuster, that there are some renovations that were done pursuant to the water damage itself and covered by insurance?
I would assume so, yes.
Okay. I'm going to turn everyone's attention to House Exhibit 703. Again, it's a business record. It's Cupertino Builders. There's a business record affidavit, and it's been on file for over 14 days.
Any objection?
No, sir.
Admit 703 into evidence.
Stacy, would you please pull up the face of the email that's attached? Mr. Wicker, do you recognize the name of the individual who sent the email?
Kevin Wood.
And who is Kevin Wood?
Kevin Wood was the lead contractor at the Paxton's home renovation.
Is he someone that you met personally?
He is.
How many times did you see or speak with Kevin Wood?
At least a half dozen.
And do you see that on the to line is the name Raj Kumar?
I see, and yes, I do.
And moving down further, do you see that Nate Paul was or N Paul at worldclass.com was the person who emailed Kevin Wood?
I do.
Where is that? What are we looking at?
Is the body of that email related to home items or repairs, things that need to be done?
It would appear so, yes.
I'm going to have Stacy then turn to the first couple of pictures in the file. Can we see the next? Does anything about the home being depicted look familiar to you?
Several of these images do appear to be, that's the Paxton's dining room.
Are you wondering or are you sure?
No, I'm positive.
Thank you. On how many occasions were you at the Margranita home in the summer of 2020 during renovations?
During the renovations, half dozen.
Okay. And do you recall any times that you were present where Kevin Wood and Ken Paxton were both there?
I do.
I'm going to turn your attention to a conversation about the kitchen. Do you recall whether or not there was any damage to that area of the home?
I do not.
Would it make sense then that these are things external to insurance coverage?
It would make sense.
We're in Pennsylvania, where I'm from, Bucks County.
In regards to being an adjuster or assisting the adjuster, rather?
Not to my recollection.
Okay. Can you walk us through any conversations you overheard between Kevin Wood and Ken Paxton?
Objection, Your Honor. Anything Kevin Wood may have said would be hearsay.
At this stage, Your Honor, it's not being offered for the truth. It's to set an anchor. I will get more specific in a moment.
Again, Your Honor, the question is very nonspecific, and anything she's going to ask about what Kevin Wood may have said is hearsay.
Your Honor, it is clear from the course of the conversation that Kevin Wood was acting as a service provider. At that point, the truth doesn't matter. At the point in which it does, it goes to his motive, intent, and plan.
Again, Your Honor, you've already... She just said what Kevin Wood said wouldn't matter. I agree. Hearsay and irrelevant.
I didn't say it ultimately wouldn't matter, Your Honor. It will matter very much.
Sustained.
At the moment, she's like the smartest person in the room.
Did you get an idea as to what the relationship was between Ken Paxton and Kevin Wood?
Busby's pretty good too, but she's definitely...
Kevin Wood was the lead contractor.
She's definitely very good.
And if Mr. Paxton then wanted additional things or changes to the renovation, whom would he speak with?
Kevin Wood.
Is there any other way Mr. Paxton would find out the timing of renovations or the duration of renovations or the cost of renovations other than Kevin Wood?
Objection, compound, and speculation. She is asking what Ken Paxton would do and what he would know. That's pure speculation.
It's an operative fact, Your Honor. There's no other way for him to know it.
Again, she just asked what Ken Paxton might know. That's speculation.
I'm going to overrule. You can answer if you know.
Not to my knowledge.
I don't even remember the question at this point, frankly. I might have to read it back. At any point, were there conversations about changes to the property?
Yes.
Isn't that the entire point of a contractor?
Yes.
And at any point, were there discussions about particular items in the home?
Yes.
Would what matters to you be whether a counter is granted or not, or whether the renovations are occurring at this stage?
Objection, vague, and relevance.
Did you care what his countertops were made of?
Again,
why would he?
It doesn't matter whether young Drew Wicker cares about the countertops. It's irrelevant.
Overrule.
Did you care what the countertops were made of?
No.
Did anything about a conversation related to countertops concern you?
Objection, hearsay.
It is not being offered for the truth of the matter asserted. There's no statement. It asks if he overheard something he was concerned about.
She just asked for hearsay right there, Your Honor. That's hearsay.
No, Your Honor, it goes to state of mind.
Overruled.
Thank you. At some point, did you hear something that concerned you?
Yes.
What was that?
Objection, hearsay.
Your Honor, there's three places. One, nucleus of operative facts, because it goes to the center of this.
Nice.
Specific to hearsay, it goes to state of mind. There's no other way for General Paxton to know how long something is going to take or what it will cost other than speaking to his contractor. And finally, it goes to Drew Wicker's state of mind in regards to what he does next because of what he heard, whether the statement is true or not.
Your Honor, we need to know who she's talking about was speaking. I think she's trying to elicit testimony about what this man heard a contractor say who has been subpoenaed and who could come here and testify. This is not the right witness for that.
going to overrule. You're not saying it's the truth of the matter, just the statement was made.
That's at this point, Your Honor. Mr. President, thank you. What did you hear that concerned you?
Kevin Wood stated that he would check with Nate on several of the items.
Now, was that about how long something would take or when something would be delivered?
No, sir. No, ma'am. It was with regards to cost.
Now, if Kevin Wood's a contractor who's trying to make money on his own, why would he need to check with anyone?
Objection, speculation.
Sustained.
So let's back up a little bit. What would he have to check with Nate on specifically? Please tell us in detail what you recall.
He was stating that he would need to check with Nate on the cost of countertops and renovations to the cabinetry in the kitchen.
I'm going to be very specific. Did he have to check on the cost, or did he have to check on, did Mr. Wood seem to already understand what the cost would be?
Yes.
And what was the cost?
He mentioned the total of $20,000.
For what?
For the cabinetry and the countertops.
And what was Ken Paxton's response? That he wanted to do it or did not want to do it?
He stated that he would like to move forward.
And then what was said by Kevin Wood?
He said, I would check with Nate.
Did you relay that conversation to anyone?
I related to two individuals.
Were either of them people who worked above you at the Office of the Attorney General?
Yes.
Were you relaying the information to be salacious or for another reason?
I was seeking advice.
And who did you speak to?
I spoke to Mark Rylander and Blake Brickman.
What did Mark Rylander or Blake Brickman advise you to do?
Objection, hearsay.
Your Honor,
Sustained.
Okay. What did you do after speaking to Mark Rylander and Blake Brickman?
I spoke to General Paxton.
What did you say to Mr. General Paxton?
I asked him about the conversation that I'd overheard, and I stated that I walked away with a certain impression.
Let me pause you. With what impression?
I walked away with the impression that Nate Paul was involved in the renovations of General Paxton's home.
What concerns did you have about that?
Given the fact that we were working on several items related to Mr. Paul, it felt as though there might be an inappropriate relationship there.
Were you that clear with the general?
Yes.
And what happened?
He stated that he appreciated me bringing his concern to him, and that he then assured me that that was in fact not the case.
Did his explanation absolve all concerns?
No.
How did you feel at the conclusion of that conversation?
Still uneasy, but I never discussed it after that with him.
Okay. Are you aware of the fact that we've issued subpoenas for Kevin Wood for him to address these issues and that he does not intend to testify before this court?
Objection, speculation. She's just testifying now.
Sustained.
Did you spend much time at the Paxton home after that?
Not much, no.
Why not?
It was a mix of ongoing renovations, increased travel, and just lack of requests to be there.
Did you feel comfortable about the home or being present at the home?
Not always, no.
Why is that?
There were still some lingering concerns over the questions that I had asked the general, but I had not followed up on those concerns.
In the summer of 2020, prior to the whistleblowing allegations, did you have an opinion as to the veracity or the truthfulness of Mark Penley?
Yes.
And what was it?
He seemed to be an individual of the utmost integrity.
And did you have an opinion as to the credibility or truthfulness of Jeff Mateer?
Yes.
I'm sorry, it's not proper for one witness to talk about whether another witness is truthful. That's just not how it works.
It absolutely is, Your Honor.
Please let me finish and quit interrupting, please. Your Honor, it's not proper for one witness to sit up on the stand and say, this person's truthful, that's not how it works. It's improper. I object.
He's absolutely right in a vacuum. I would have no authority to talk about the character of truthfulness as a primary rule, and I wouldn't infringe it. But once he attacks their credibility, Rule 405A1 allows me to establish by reputation or opinion a relevant character.
You go get him, girl. You go get him.
That's not how it works, Your Honor.
Yes, it is.
Anyway, this is not how it works, Your Honor. You don't get to get up here and bring one witness and talk about the veracity of all the other witnesses. Now, if she feels like Mr. Penley's veracity was challenged on some particular statement, then she brings a different statement to try to rehabilitate him. But she don't do it with this witness.
You could do it with any witness, Your Honor.
She's right. She's right. You go get him, girl. Go get it. Go get it.
We'll sustain the objection.
How did you communicate with Ken Paxton in 2020?
Through email and text message and phone calls.
How many cell phones did Ken Paxton have?
He had 2 primary, and he later obtained 2 more cell phones.
I learned through the course of opening that I used the term burner phone incorrectly. Apparently, they have to be cheap and from 7-Eleven. What would you call extra phones that most people don't know about?
Extra phones.
Okay, so two primary phones, 2 extra.
That is some snark, and I am here for it.
His personal phone.
You bring that snark, babe.
And would you give us the last 4 digits of that, please?
The cell phone is 8128.
And what about his work phone?
0220.
Can you describe for us physically what the other 2 phones look like?
The other 2 phones being the extra phones?
That's correct.
Okay. The other 2 phones, one was a Samsung Galaxy Fold, the other was a red iPhone.
You mentioned that you also communicated with him by email. Outside of work email, did he have another?
He did.
What kind of account was that?
It was a Proton mail.
And do you know how the Proton account was set up?
It was set up through the AG's office.
Why was that?
We went to China.
So it was safer to discuss business on that phone than it would be for a Chinese hacker to get into a personal cell or a work cell, correct?
Yes.
But do you also know that their headquarters are out of the United States?
I believe they're in Switzerland.
And so they wouldn't be subsequent to a search warrant and are not provided as part of a public records request to the OAG.
Objection, speculation, Your Honor.
Sustain.
And are you familiar with something called Signal?
I am.
What is that?
It is an encrypted messaging app.
Encrypted, also making it safer, correct?
Yes.
Are you aware that they too are housed out of the country, not subsequent to, or not under the pressures of a subpoena and not provided by the OAG?
Again, Your Honor, this is just her testifying what she thinks Signal is. This witness doesn't know this. It's speculation and improper.
Sustained.
At any point, did General Paxton ask to use technology that you provided?
Yes.
What was that?
He used my personal cell phone.
How many times did the general use your personal cell phone?
At least 3 to 4.
Were you able to hear those conversations or who they were with?
I was not.
Were you able to determine after you got your property back why he needed your phone?
No.
Why not?
Whenever I received my cellular device back, the call log had been wiped.
And did he use anything of yours other than your cell phone?
No.
Do you recall after the whistleblowers, Mr. Paxton asking to use your laptop?
Yes.
What was that about?
That was a request. He was working on a letter to the Inspector General of the United States.
Can you anchor that in time for us? What had just occurred?
This was late October, and this would have been after the whistleblower complaint.
And do you know, what were you asked to do?
I was asked, General Paxton handed me a hard copy of a document and asked me to transcribe the events outlined in the document in the form of a letter to the Inspector General.
And by hard copy, you mean like what I have here?
Yes.
So not handwriting, but typed written?
Yes.
Why would you need to be provided a typed written copy of anything that's already in electronic format?
Objection, speculation.
Overruled.
Why would you need to be provided a hand copy of anything that's already in electronic format?
I don't know.
And what were you asked to do? Transcribe, you said?
Yes.
Were you making additions or deletions?
I did make several additions, yes.
What kind of additions?
Since it was asked to be in the format of a letter to Inspector General Horowitz, it was addressed to Inspector General Horowitz. There was a slight introduction that I'd been asked to include, and then this sign-off was asked to be as General Paxton.
At this time, I offer House Exhibit 573. This is part of the Office of the Attorney General records. There is a business record affidavit. It has been on file for greater than 14 days.
Any objection?
Do we know about this? No objection, Your Honor.
Please admit Exhibit 573 into evidence.
Mr. Wicker, will you take a moment and look at the body of that letter and let me know if you recognize it?
This is the letter that I was asked to write for Inspector General Horowitz.
So if I turn you to the top where you add Dear Mr. Horowitz, you typed that in?
Yes.
Do you know who that is?
He was or is the Inspector General of the United States.
We've heard about the Office of the Inspector General throughout this trial. Do you know whether or not that's the appropriate person to go to if you want to make complaints about federal prosecutors or federal agents?
That is my understanding, yes.
At any point prior to the whistleblow situation, had Ken Paxton talked to you about or in your presence about the Office of the Attorney General?
About the Office of the Attorney General, yes.
Had he ever suggested going there or that they were the correct place to bring this complaint?
He had not mentioned that to me, no.
In fact, do you know that he didn't want to take it to OIG prior to that?
Objection, speculation.
Overruled.
Do you know whether or not he wanted to take Nate Paul's complaint to the OIG prior to the whistleblowers coming forward?
I do not.
And then once you look at this letter, I'm going to turn you down to the bottom in regards to the allegations made by Nate Paul, and I'm going to go quickly. Did these amount to things like not getting to use the restroom?
It did.
And when you drafted it, did you realize part of Nate Paul's big federal complaint is that he couldn't call his attorney except from using an agent's cell phone?
Yes.
And that he was not allowed to call for counsel, and that's why they provided him a cell phone?
Yes.
Are you aware that the only allegations he makes, well, let me do this differently. Where were you when you were helping type this up for the general?
This letter was written in the Office of the Attorney General.
On what laptop?
My state laptop.
And what did you do with the laptop after typing up the letter?
I followed up with General Paxton about having completed the transcribed letter.
And then what?
And I asked him what he'd like to do with it.
And what was the response?
He said that he had several insertions that he would like to make and that he would let me know about when he needed it.
Did he have you email him or put it into a USB drive?
Not to my recollection, no.
What did he do?
He asked me to bring my state laptop to his Austin home so that he could work on the letter.
And did he make changes to your knowledge?
To my knowledge, no.
Okay. Okay. After drafting the letter for the Attorney General, do you know whether or not the letter was ever sent to OIG?
I do not.
Let me turn your attention then to the conclusion of your career there. What was the status of your job?
The status was that I was both the scheduler as well as the executive aide.
Well, I mean, it's at the end, in October of 2020, leading into November. Were you offered a promotion? Were you offered a change in job function?
I was.
And what was that?
General Paxton had expressed an interest in myself taking on greater responsibilities with regards to certain policy areas, and that I would continue with my present job responsibilities, but also take on the additional policy-related responsibilities.
And at some point you'd mentioned that FBI had reached out to you and you make Ken Paxton aware of that. Is that accurate?
Yes.
And what did he do?
General Paxton's question that he asked me was why?
Did you have a response for him?
No, I did not.
What, if anything, did he direct you to do?
He did not direct me to do anything at that time.
Did he take you anywhere?
Not at that time, no.
Okay. Ultimately, you say not at that time. So what happens next in regards to that?
The next discussion I had with a member of the AG staff regarding the FBI was Brent Webster requested to meet with me.
And what, if anything, did Brent Webster have to say on behalf of the Office of the Attorney General?
Objection, hearsay, Your Honor.
Sustained.
Was he working in his official capacity as a representative or employee of the Office of the Attorney General?
That is my understanding, yes.
Same question, Your Honor, subsequent to 801 ED, which is specific to representatives or employees. Brent Webster is making the comment to Mr. Wicker in his capacity as an employee of Ken Paxton.
It's the same objection, Your Honor. We've established in this trial, that's not how it works. You cannot just come up here and ask him what somebody else said other than General Paxton himself.
You can when he's being directed as part of his employment.
There you go. You get him.
He's not an employee of Ken Paxton.
He's an agent of Ken Paxton, so we'll overrule.
There you go.
What, if anything, did Brent Webster tell you?
Go get it.
Mr. Webster said that he understood that the FBI had reached out to me and that I should not respond.
Did he tell you why?
He said that I ran the risk of incriminating myself.
And did he then bring you back to Ken Paxton?
Eventually, yes.
What was that conversation about?
He believed that there was an opportunity to assert attorney-client privilege.
So he too wanted to prevent you from speaking to FBI?
It certainly seems that way, yes.
And were you asked to speak to anyone else about this?
Leslie French.
And what did she tell you to do?
Leslie French advised me that she had been through something similar and that there was nothing to worry about, that the AG's office would provide me with counsel while I met with the FBI, and that there was no need for me to bring my own counsel.
What was your response?
My response was that I would feel more comfortable retaining my own counsel that would look out for my interests.
There you go. Good for you.
Why did you respond that way?
Because that's where I would have been that's how I would have felt comfortable in that instance.
After all of this, what decision do you ultimately make about this promotion?
The conversation that occurred regarding the promotion was all at once.
Yeah, if anyone's ever says to you, don't worry, we'll bring a lawyer for you, you probably should worry.
General Paxton that I would not be taking the promotion, but I would gladly accept the responsibilities.
Why were you making that distinction?
I did not want the general to have the appearance of having offered me anything in light of the FBI reaching out.
So you were trying to protect the appearance of what that would look like for General Paxton?
For General Paxton and myself.
Thank you. Did you ultimately put in your notice and quit?
I did resign, yes.
Was that on November 2nd, 2020?
If I recall correctly, yes.
Makes sense then that payments would stop, is that correct?
Yes.
And did they stop from the Office of the Attorney General?
They did.
Did they stop overall?
No.
What else were you providing?
All right, I need to use the facilities. I'll be right back, guys.
Continue to be provided.
Talk amongst yourselves.
Stipend by the campaign.
Did you notify Ken Paxton's campaign that you were still receiving money and that you should not be?
No, I had let them know that I was leaving and to cut off my access to both the email and the calendar, and that I should cease receiving stipends.
When did you cease receiving stipends?
Not until the following year.
And what, if anything, did you do with that extra money that you had been provided?
Michelle Smith had sent me a W-2 with that amount. I contacted her, not understanding that I continued to be paid. I asked her what I should do with the money and if General Paxton would like it back. She reached out to General Paxton, who informed her to tell me to keep it. And I stated no problem, and I went ahead and donated the money back.
They told you to keep it and you donated it back?
Yes.
Why did you do that?
I didn't do the work.
How did you feel about receiving money from Ken Paxton's campaign after you ceased employment and in light of all the facts relevant today?
I have no reason to believe that it was with malicious intent. It might have been an innocent mistake.
I think maybe more specifically, I'm talking about your character. What made you return it?
I didn't put in the work, and I did not want any instance, I didn't want it to appear as though I might have any conflict of interest if anything like this ever came about.
Thank you, sir. Pass the witness.
We're going to take a break now, and members, we went longer in this section, so we'll take a 20-minute break, and then we'll go till 12:30. We'll move lunch 12:30 to 1:30 today. So be back here at 15 minutes after 11.
Yeah. Yeah. Benny, she's a very good attorney. I don't know what to tell you. I like her style. I am critical of male attorneys. I'm critical of female attorneys. I praise male attorneys. I praise female attorneys. I mean, not to put too fine a point on it, but I did gush all over Buxby the other day, right? And it's like how great he was and just gushing over him completely. So I don't know what you want. MD said he resigned, volunteering to resign. He didn't get fired. That is not necessarily a correct conclusion. Constructive termination. We've discussed this, right? Just because he resigned doesn't mean he wasn't fired. So yeah, the question, and also it doesn't mean that he wasn't retaliated against. So Busby, yeah, sorry about that. She did make a mistake in calling counsel dishonest, and I called her out on it when she did it. Yeah, I said that was a mistake when she said it. That was, I called that too. So I'm not disagreeing with you. Membo says she was mean, but a great examiner. I don't think she's necessarily mean. She is direct, a little cold, calculated, perhaps slightly frustrated because things are not going the way that she thinks they should go and because she's getting frustrating rulings. And so perhaps a little frustrated and also perhaps a little upset at the position that her cohorts have put her in. She's like, well, now I have to clean up this shit and you haven't given me enough time. So you've put me in a negative position. So that could be some of what's coming through. MD said he resigned. We agree with you. That doesn't mean he wasn't fired. Constructive termination is a concept understood in law. Yes, he resigned, but it doesn't mean he wasn't fired. If I have to explain this again, I'm going to get salty. Mambo says, great point. Thanks. Yeah. So like, it's just like, I praise Busby. I praise this woman, critical of Rusty, pretty complimentary to the other guy on their team, that other guy who's been asking questions. He's been pretty good. I'm not sure they've had anyone really bad on the defense team. as opposed to the prosecution's team, which has been, yeah. MD says, where's this conspiracy? The evidence of the conspiracy is there. I have a sneaking suspicion that if it were a Democrat being impeached, you wouldn't ask that question. I'm just guessing. The witness just said on the stand he didn't get fired or retaliated against. Well, then fair enough. Then fair enough. If he said that, then, you know, okay, great. Then he wasn't fired or retaliated against. Cool. Noted. So yeah, that would be fine. Then in that case, he wasn't retaliated or disciplined, or yeah, fair enough. How's the trial been going? Paxton has some weak spots, to be sure. He has some problems. 1, 5, 6, and 16 are not great. Update to cross. Okay, fair enough. I will do. I'm wrong all the time. That's possible. But you know what I do when I make a mistake? I admit it and correct it. That's the sign of an honest person. If I make a mistake, I'm like, okay, I made a mistake. Let me correct it. Wow. Admission that you made a mistake. Wow, what a bastard I am. Yeah. You'll never find a lawyer who will agree with you all the time, or even a judge who will agree with you all the time. I don't even agree with myself all the time. You know, I don't always agree with myself because I'm a human being. It's amazing, right? I'm a human being, and sometimes, you know, I don't even agree with myself. So I can promise you that as a judge, if I ever become a judge, I will make mistakes. Wow. I know. It's almost like I'm a human being. I will make incorrect rulings from time to time. I will make mistakes. Hopefully, I'll be wise enough to catch them and correct them, but possibly not. I'm almost like it's a human being. It's amazing. Wow. Yeah. You know, some court of appeals might overrule me. I may agree with them or not. Court of Appeals can make mistakes too. The Supreme Court can make mistakes. We've discussed them. I was thinking about filling out a position for a judicial clerkship at the First Circuit Court of Appeals in Texas. So I've been mulling that and working on that in the background. Am I streaming Friday? Yes. But I won't be streaming Saturday. Well, it depends where we are on Friday. If this thing is over, then maybe not. If this thing is still going into Friday, we'll stream Friday. If this thing is over by Friday, then I might take the day off. We'll see. But we'll get there when we get there. E-Loser says, morning, Kurt. Let me get coffee for you today. Thanks for the coverage. Thank you very much. Chio has been a member for 3 months. Sandy said held in abeyance. We discussed that. They decided to put some of the charges on pause because the tech crisis says, so how's the case looking? Paxton has a lot of weak spots on 1, 5, 6, and 16. Other ones are more dubious. The whistleblower remains the best charge against him, in my humble opinion. Chuck in Tennessee says, Kurt, appreciate the way you break it down so the layman can understand what's going on. You're welcome. Tina says, real life trials aren't always sexy. God, isn't that true? Thanks for the coverage you do. She's emotional, nasty, and angry, said Mambo. Disagree strongly. I disagree that she's emotional. She's pretty cold. She's maybe slightly tilted, but it's very slight. Perhaps slightly frustrated, but again, it's very slight. She's not nasty. I don't think she's necessarily angry. She's a little frustrated and a little tilted, maybe. I think you're being mean. Sherry became an uncivilian for 99 cents. Mambo said, still think she was mean, but a great examiner. Don't think she was mean. Mambo said, great point, thanks, and you're welcome. She has been handed, I'm willing to cut her some slack because she's been dealt a bad deal. You know, she's been dealt a bad deal. She has been hampered somewhat by her more senior members of her team, and she's better than them, and she is frustrated, and I'd be pissed too. And now she has to fix this shit, a position I understand. It's like, now I have to fix your mess. And so, yeah, she might be a little frustrated, but that's okay. But she knows chapter and verse. She's got it cited. She's got the right argument. She's being very professional. She understands exactly what she's doing. She understands it cold. She's got it down. She knows exactly what the right argument. She's battling Busby, you know, point for point, saber for saber, and more than holding her own. So that alone is an accomplishment, even where she's losing. And I'm not sure that she should lose. You know, we were trying to look up the exact standards in Texas on the whole issue of the conspiracy and what you need to prove, sort of as the initial matter, and we couldn't find it exactly. What I could find apparently is that the case law, where the history is all over the map, apparently the level of proof you need historically for how much evidence do you need to show the conspiracy exists for the hearsay exception, apparently, and I was reading some articles in the background, apparently the history is everywhere from prima facie to beyond a reasonable doubt. So that's just basically every possible standard. That's every possible standard. How much do you need to prove it just to admit it? Prima facie versus beyond a reasonable doubt. Well, that covers every possible, that covers every possibility. So that's real helpful. The best I can find is apparently under the federal law, you need, what did I even say? I don't even remember what it is at this point. What was it, preponderance or I don't even remember what it was. So I don't even know what it is in Texas about what do you need to do it exactly. The conspiracy hearsay exception is a paradox? A little bit, yes. And whether or not, and even there's a split of authority as I was reading law reviews in the background, as you're wondering what the hell I'm doing, because I'm trying to look up some legal analysis. Apparently there's is the statement itself, is the statement that's being excluded by hearsay itself enough to overcome the hearsay, or do you need something external? So can you bootstrap this? Apparently there's a division of authority, at least historically. So you can use the very statement that's being excluded by hearsay to establish the conspiracy to overcome the hearsay, and around we go. So apparently, historically, yes, you could bootstrap it, but apparently there was a division of authority on that. So fun and exciting. I was referring to a Nixon case, yes, in which the Chief Justice said something like clear, and I don't even remember what the Chief Justice said. All I remember was reading it and saying, well, that's not particularly helpful. The Chief Justice's opining was not particularly helpful, in my opinion. It didn't illustrate the answer. The answer was not helpful in this jurist's humble opinion. The Chief Justice of the Supreme Court writing something that is vague and unclear and unhelpful? What a shock. I don't know what to do with this. Well, there's a first for a lawyer, right? I don't know what to do with this statement from the Supreme Court. It's a little vague. Never seen that happen before. Klein evidence. That's good. Yeah, it's Klein evidence. It's inside itself. Yeah, that's good. I like that. So I don't know exactly what the standard is. If Matt shows up in chat, we'll ask Matt. Maybe Matt will know what it is exactly. I wasn't able to find out through a quick public search as I was trying to do like 2 or 3 things in the background. Watch chat, monitor levels, respond to the person, do legal history, and also filling out applications for judicial clerk. I was doing like 6 different things in the background at once. Sometimes it's hard to be a streamer. We press on. Wasn't there a case where defendant retracted his testimony was used against his co-conspirators? Yeah, probably. There was a case also this year at the Supreme Court dealing with the right of confrontation when the co-conspirator statements implicate another conspirator. That case came up in the specific context of a confession to the police, but I'm not sure it matters. Yeah, that was a really weird case. That was a really weird case. Yeah, because you kind of have to retract their names, but the implication is so obvious that it doesn't really matter. I'm trying to remember the exact case, but I'll paraphrase it a little bit, right? So you had 3 people involved in a conspiracy, 3 people involved in an alleged conspiracy, right? And so one of them gives a statement and mentions all their names, and another one of them doesn't want to take the stand or apologize. The statement is being used against one of the conspirators. This person who made the statement isn't taking the stand. So you can use the statement against him, but because the statement implicates another member of the conspiracy, you can't use it against them because he can't confront the witness. And right, it's a statement against him. I don't think I explained that adequately. Let me give it another try as I try to like not mess up the pronouns and stuff. Let me give this another shot. All right. A guy gives a statement to the police. In the statement, he implicates himself and 2 other members of the conspiracy that he names in his statement. This guy who gave the statement is not taking the stand. He's invoking his 5th at this point. Okay? The government wants to use the statement against the guy. They can do that. It's a statement against interest. The problem is that the statement implicates another of the defendants who also has a right of confrontation, right? Because this is a statement being offered by his co-conspirator who he has a right of confrontation against. But the guy who gave the statement has a 5th Amendment right not to take the stand. So we have this problem, right? You have a right to confront the witnesses against you, but he has a right not to take the stand. So what do you do? So the prior case law says, okay, just redact his name. And that's enough. And so the Supreme Court was dealt with this possibility in this case, this term, because you have 3 guys on trial. They're all sitting at the defense table together. The statement can be used against the guy who gave it and also the other co-conspirator. I forget exactly why. It doesn't exactly matter for the purposes of this, right? So the statement is allowed to implicate the other co-conspirator. I forget the exact details. It's not important. But the 3rd co-conspirator wants it done, right? So like you have the statement, it was me, Bob, and another person who we're not naming. And the people at the defense table are me, Bob, and Joe, right? So it was me, Bob, and some other guy who we're not going to tell you about. And at the defense table are me, Bob, and Joe. Who could this mystery 3rd person be? But that was deemed sufficient by the U.S. Supreme Court because it could be referring to literally anybody who may or may not be presently at the defense table. We're not going to tell you who it is. Some mystery 3rd person who we're not going to mention by name. Also, have you noticed Joe is sitting at the defense table? It may or may not be, Joe. We're not going to tell you about it. The Supreme Court said that was fine, which I thought was pretty hilarious. Thank you, Sandy, for the 50 gift memberships. That's incredibly generous and very, very thoughtful. Thank you very much, Sandy, for your kind contribution to this. It is extensively appreciated. Don't make fun of my face, okay? That's not fair to Uncivil. All right? We are pressing on. That's not nice. I tried putting on concealer. The concealer can only apparently do so much. Is my hairline fair game? That's also mean to Uncivil. Let's not be mean to Uncivil. That's not very nice. It's just a testament to my youthful vigor. It's a testament to my youthful vigor and the fact that age has not beaten me down. What is my opinion about the verdict of the case? Do I believe there's enough evidence to convict, or do you believe the votes were cast before trial anyway? Well, that question I'm not going to answer, because that question requires a political analysis, and I don't do political analysis. Not for at least reasons I'm not particularly good at it. Right? It's not my specialty. I'm not a specialty in political analysis, except to the extent that, you can kind of know what various people are going to take on various positions, but, I don't know. The fix may be in, I don't know, but we're going to try to do a legal analysis notwithstanding. So, the fix may be in. The senators may very well know how they're going to do, and this is all kabuki, but regardless, we're going to try to analyze it on its own terms, like good legal thinkers. And I think that's all we can sort of do, and try to assess the strength of it from a legal perspective. And what the jurors will do, who hell knows? Trying to forecast this is not in my domain. Trying to forecast a jury, is difficult at the best of times. And it's a fool's errand here. So we'll take a pass on that. Unfortunately, it won't pop yet. So that's part of why it looks angry. I may have tried. Let's move on. Let's not shame Uncivil. I could put up a different thing. Okay. Yeah, we won't look at Uncivil anymore because Uncivil doesn't look good. We'll just have the logo. You don't need to look at Uncivil. He's a hideous freak. Yeah. 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 Can I explain my views about Nate Paul? I have no particular views about Nate Paul beyond the confines of this trial. I don't really follow politics very much, in great depth, in sort of the internal machinations of it. So, I sort of saw some headlines that the Attorney General had been indicted for the securities case. I knew that, but I don't think I knew Nate Paul's name before this case started. So I have no particular views of Nate Paul beyond what I heard. I suppose from the context of the trial, I would say that Nate Paul is seems like a slightly conspiratorial guy who believes that, everyone is out to get him, in some sort of illegitimate way, and believes, the powers that be have selected him for selective whatever. So, yeah. Witch hazel? I have some witch hazel. I could throw that on. The next round of Supreme Court cases starts the first Monday of October, is when the Supreme Court session begins. The first Monday of October. Am I on Twitch? Yes. I don't really use it, but yes, technically. Lansing? Yeah, Lansing. Yeah, it's not ready yet. I put on some cream. I put on some benzoyl peroxide. I've been treating it. We'll just press on. Amica cream. I don't have any Amica cream, so yeah. Hydrocoil bandage. I do have that. Yeah, I've been putting that on. I didn't put it on because it reflects the light. So I didn't put on the bandage because, I thought it would be more distracting to have the bandage on. So.
Mr. DeGuerin?
Yeah.
Could you come forward? Miss Epley?
So we'll decide whether that's the right call, I guess. I have a date tomorrow night, by the way. So this is, that's why I'm ending early, because I have a date tomorrow night. So I am super thrilled about this and really hope that my skin's going to calm down before then. I thought, 7 p.m. would be late enough on Thursday. I thought that would be a late enough time. I thought surely we'd be done by then, but now I'm like, I'm not so sure. So yeah. In this application for the judicial clerkship, they want me to use the standard application for Texas for apparently all state positions. And in employment history, it says include all employment. Like, to when? The beginning of time? Do you really need to know about, my first job as a bagger? At Harris Teeter? We could mess with the voices on voice mod. That might be fun. Let's mess with the voices on voice mod. It's like, do you really need every job I've ever had since the beginning of time? I mean, they do put the word all in all caps. So that's kind of frustrating. Let's take a look at voice mod and see what it has to offer for all the fun voices we can do. All right, let's see what we got. So while we're waiting, let's see. All right, so we got a couple different AI voices that we got. So let's just go through them and see what you guys think. All right, so we got AI Joe that kind of looks like a grumpy old guy. All right, let's give Joe a shot.
Okay, so apparently it's described as Joe smokes way too much. Does Joe smoke way too much? Is this doing anything for everybody? Is this, yeah, good? Yeah, you don't really like that one. All right, so now we gotta try Jackie, who is a girl with blue hair. Let's give Jackie a shot.
Okay. So, apparently I'm some sort of gamer girl, I guess, or something, I don't know. So, that's exciting and fun. Alright. Bob's Burgers. Could be. Some of the female voices are kind of fun. Just because, like, what you can do in terms of the female voices. Let's see. Let's try Claudia. Let's give Claudia a shot.
All right, so is Claudia good? Check 1, 2. Yeah. So some of the voices are better than others. I don't know. Sound vaguely like one of the gamer girls I'm following on Twitch. Claudia is an ordinary woman who hoards Tupperware, apparently, in the description. So, yeah. What is a Curie? A Curie? This is gotta be some sort of sickeningly cute voice, I can already tell. Let's give this a shot.
This is voice mod's very own mascot voice. Okay. Check 1, 2. Oh my god, this is just sickeningly cute. I can tell. This is great. So yeah, all kinds of stuff.
So, yeah, some of the fun voices that we have. This program is called Voice Mod, by the way. It's about $20. Recommended. And there's like all kinds of AI voices, and then there's, you know, different mods and do all kinds of stuff that they can do. So for $20, it's a pretty good app. There's one called Creepy Doll. Do you guys want to hear Creepy Doll? It's supposed to be a creepy girl doll.
And then there's this one called Persona, where you can just adopt different voices. So this one apparently is supposed to be just a generic young woman in Persona B. I don't know what the difference between all those are, but this is apparently just supposed to be a young woman. So Apparently. This is not the creepy doll. This is just generic young woman. Sounds artificially about than great.
So, some fun. Let's try Haley, see if that's any good.
AI voice Haley. My name is Haley. I'm here to say, I hope y'all like Uncivil and Uncivil Law. Wiki, 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 wiki.
I'm not sure there is an original voice actor for any of these things. So yeah, that's fun. And then you can do like soundboard stuff where you can just push buttons and there's a whole bunch of soundboard stuff. So it's not bad. I use it just to clean up the audio a little bit, mostly. Just to make it a little bit more present and make it a little bit more bass. So I basically used it to try to like make the mic like a more like a SM7B, you know, just use a $20 app to try to like make the mic sound a little bit more bassy and a little bit more full. So you can do and clean up the audio a little bit. What else can we talk about while we're waiting? Top 5 articles so far. I mean, yeah, the ones we've been doing. Yeah, but 1, 5, 6, 16 are the best. The hiring of the guy to interfere with the MIDI Foundation. The hiring of Kamek. Or the intervention into MIDI, rather. The hiring of Kamek. The retaliation. And the conspiracy are the best. Still no evidence involving.
Give us a minute.
The hiring of the mistress, apparently.
Solving some issues here.
They caught the escaped convict, I heard. A vacuum tube mic, compressor. Maybe. Owen Stroker ruling? I'm not familiar with the ruling. Should I look it up? Owen Stroyer. Who's Owen Stroyer? And what ruling? Let's see. InfoWars host sentenced to 60 days for Jan 6. I don't know. I can't comment about it without going into the details about it. It's impossible to speak about it without looking into the particulars. The best I could do would be to like look at the prima facie case as submitted by the DOJ. Let's see what the prima facie case was, as long as we're doing something.
We have a motion to be brought in court by the House managers, I understand.
Mr. President, yes, we'd like to present a motion for reconsideration and amendment of the Senate Rule 27 and 30A.
Please bring it forward.
Yes, sir.
I'm not going to read the whole motion, members. You will have an opportunity to do that later. In short, they want to amend the rules so that after deliberations, when you vote for acquittal or conviction. If you vote for conviction, it automatically prevents the Attorney General from serving in office. Again, they want to combine that. That's what the motion is. It has to lay out for 24 hours. It's 11:30, so we would not take it up until 11:30 tomorrow, and that will come to you to do with as you decide. You can table it, you can take it up, whatever you decide. So I want you to be aware of that motion because that's the proper procedure if the parties are making a motion to bring it to me and for me to share it with you.
All right.
Thank you, Your Honor.
I can't.
Okay if I call you Drew?
I can't read this and adjudicate this and also listen to this, the same thing. It's too much. So maybe during a break we can come back to it.
Okay.
Yes, sir, that is okay.
I hope you don't think I'm being disrespectful.
Yeah, go ahead.
We did speak on the phone a couple of nights ago.
Yes, sir.
Okay. And you also talked to these folks over here as well?
Yes, sir.
Okay. I want to clear something up. When you were working as an aide to General Paxton, you were getting paid not only from the state, but also from his campaign.
Yes, sir, that is correct.
Because you were doing some things, not only for the state, but you were doing other business for General Paxton.
Correct.
And so it would make sense that you would be paid by both entities.
Yes, sir.
And as I understand it, you were getting paid direct deposit by the campaign?
Yes, sir.
Okay, so just to clear this up, when you decided to leave the AG's office and go and work in your family's business, somebody forgot to turn off your direct deposit from the campaign.
Yes, sir.
It wasn't somebody like still giving you checks. It was just an automatic direct deposit.
Objection, speculation.
I mean, you know how you're getting paid in your own bank account.
I'll sustain the objection, but you can ask again.
You know how you were getting paid. It was a direct deposit into your bank account, wasn't it?
That's correct.
And it just continued until you raised the issue and then you gave the money back, right?
Objection, speculation.
We've already heard from this.
Overruled.
Isn't that what happened when it was figured out? General Paxton said, well, just keep the money, Drew, and you decided, no, the better thing to do is just give it back to the campaign, right?
That is correct.
Okay. You talked about 3 lunches in your direct, did you not?
I did.
These were at restaurants?
Yes, sir.
In a public place?
Yes, sir.
Was anybody hiding or in a secret dark back room?
Not to my knowledge.
Anybody that walked in the restaurant could see General Paxton there, could see you there, could see whoever he was having lunch with there, right?
That is correct.
Wasn't anything secret about that at all, was there?
No, sir.
Okay. I want to make sure the members understand, Drew, because this is some things that you not only told the House when you were interviewed, but you also told me the other night on the phone. When you were working for General Paxton, you almost considered him family, didn't you?
That is correct.
You have no animosity towards the Paxtons, do you?
I do not.
And you told me you love the General, right?
That is correct.
And you also said you appreciate everything that General Paxton did for you.
Correct.
The Paxtons used to joke that you were a second son, didn't they?
They did.
You told me that you and General Paxton were very close.
That's correct.
Are you accusing, and I don't think you are, I just want to make it clear, because you were probably with General Paxton more than anyone else during that time frame that you were working for him, weren't you?
Yes.
I mean, I want to make it clear. I think that the senators know, but just for the public, sometimes you would be what's called a body man. You ever heard that term?
Yes, I've heard that term.
Yeah, and basically you're with your boss all the time until he releases you for the day.
That is correct.
So you would have been spending more time with General Paxton than anyone else, right?
Yes.
More so than even his wife, Angela.
Yes.
You're not accusing him of bribery, are you?
I'm not.
Let's be clear. The guy that spent more time, and that's you, Drew, with General Paxton than anyone else during the time frame that we're here to talk about is absolutely not accusing General Paxton of doing anything wrong at all, are you?
I'm not accusing anybody of anything, no.
Okay.
I'll go put on some more color correction.
You also were with General Paxton when he traveled, right?
That's correct.
And just so, and I know you've read some of these press reports, haven't you?
I've done my best to stay away from any sort of media. I've had some people say some things to me, but I've tried to shut that down as soon as it's come up.
And I know it's hard to ignore some of this stuff in the newspaper, but you know that there's been an allegation that General Paxton had a secret email address?
I believe you mentioned that to me on the call the other day, yes.
And you and I know that the reason he had that Proton address, that email address, was because he was traveling to China.
That is correct.
And the reason and that was something set up for him by the IT department at the Office of Attorney General.
That is correct.
And that email address was to prevent the Chinese from hacking into his into his email, right?
Correct.
Okay. And other people in the office had that same type of email address, didn't they?
I don't know how many others, but yes.
Okay. You remember the suggestion of burner phones?
Miss Epley mentioned it earlier, but yes.
Yeah, it was, and I know you probably haven't been reading the newspaper, but let's just go ahead and get this out of the way. If a burner phone is a phone, a plastic phone that you can buy at a convenience store with a certain amount of minutes, and when it's over, you break it and throw it in the trash. General Paxton never had anything like that, did he?
Not to my knowledge, no.
He never had any burner phone, did he?
Not under that definition, no, sir.
Okay. You told the House you could not speculate as to what relationship Nate Paul had with General Paxton. Isn't that right?
I stated that I believe that they were friends, yes. But I wouldn't speculate beyond that.
Yeah, that's all you know, right?
Yes.
Okay. One thing you do know, that you never were in the presence of General Paxton when he and Nate Paul made any kind of agreement. Isn't that right?
That is correct.
I mean, let's be clear. They've been throwing around this word conspiracy for literally a week and almost a half, and you were the man who was with General Paxton more than anyone else, and you can say definitively, you never saw Nate Paul and General Paxton reach any sort of agreement whatsoever. Isn't that right?
No, sir.
Is that right?
For the conversations I was privy to, that is an accurate statement. Yes, sir.
Okay. You don't have any actual knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that right?
That is correct.
Let's be clear. The man that was with General Paxton more than anyone else is testifying under oath that you have no evidence, no knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that true?
That is correct.
Now, you have seen some speculation in the newspaper and the press, haven't you?
Prior to this trial, yes.
Yeah. And I want to, and I'm not picking on you, Drew, because I think you can tell that I'm fond of you and I like you. But I want you to know that this whole idea of the house renovations, everybody says it came from you. Do you know anything about who paid for General Paxton's home renovations?
Not directly, no.
All you have is one stray comment, right?
Across multiple instances, yes.
And you were concerned about it and you went and raised it with your boss, right?
That is correct.
And he was very clear with you. That is not what's going on here. Isn't that right?
That is what he stated to me, yes.
Okay. When you interviewed with the house managers, did they ever bother to show you the receipts, bills, payments related to General Paxton's house renovations?
No, sir.
They are in evidence. Did you ever go with General Paxton and Senator Paxton when they went to Home Depot?
No, sir.
When they went to Lowe's?
No, sir.
When they went to a different Lowe's?
No, sir.
Were you ever with them when they were pricing sinks and countertops?
No, sir.
You did say in your testimony to the House that General Paxton's, I don't want to use the wrong word, but he's close with his money.
Yes.
I don't want to call him cheap because he's my client, but he pays attention to what he spends.
The word I would use is frugal.
Frugal, good word, okay. You believed, based on what some people have told you or maybe what you read, that General Paxton got granite countertops?
That was what I read in one news article, yes.
Okay, let's let that sink in. And when you read that, And when you connected it to the statement you say you heard, you thought, well, there it is. General Paxton got granite countertops paid for by Nate Paul, right?
No, sir.
You still didn't believe that, did you?
No, sir. In terms of the timing, I had already made my statements to the House committee, and the article that I read and am referencing now, I believe, came out after that.
Okay, and I'm not talking about that. I just want to make sure that at some point in time, you believed that General Paxton had gotten granite countertops, right?
I had heard that. I don't think I believed that. No, sir.
Do you believe it now?
No, sir.
Let's pull up, Eric, if you will, Attorney General Exhibit 371. You told us you had been in the kitchen of the Paxton's home in Austin.
I was.
And that's in Terrytown here in Austin?
That is my understanding what the neighborhood's called, yes.
Okay. Can we pull that up, Eric, please?
Objection, Your Honor. Is this already in evidence? And he hasn't established the relevant time period, whether it was before or after.
I've already said this is in evidence, Your Honor. It's AG 371.
Overruled.
Now, this picture, sir, was taken a few days before this trial started. Do you see the countertops?
Objection assumes facts not in evidence.
It's already been proved up, Your Honor. We'll do it again.
It has not been proven up. It is a photograph, and it depicts exactly what it reports to until or unless he lays a predicate for someone who can say when it was taken.
If I could keep going, Your Honor, we'll do all that.
Same.
Sir, do you see the kitchen, the Paxton kitchen there?
I do.
Do you see the countertops?
I do.
Are those the same countertops that you saw when you were in the Paxton kitchen?
Prior to the renovation, yes.
Okay. Do you realize that that's the same countertops as they exist today?
Objection, facts not in evidence. He doesn't have a predicate for that, and he's testifying to the Senate.
Your Honor, this has already come into evidence of the current picture of General Paxton's kitchen. It's already in evidence.
Mischaracterization of the evidence, Your Honor. The photograph is in evidence, but what it depicts has not been established, and Tony Busby does not get to, no matter how hard he tries, establish the time frame in which it was taken.
Again,
Sustained.
is this how the kitchen looked when you were in it?
Prior to the renovations, yes.
Okay. Do you see the countertops?
I do.
Do you see the stove?
I do.
Do you see the cabinetry?
I do.
Okay. Do you know how often the Paxtons went and priced new stoves, new countertops, painting the cabinetry? Do you know?
Objection assumes facts not in evidence. We don't know that they did that at all.
I'm asking him, Your Honor. How can I establish if I don't ask him that?
Overruled.
Do you know how many times they did that?
I do not.
Wouldn't it be unfair to the Paxtons to suggest that this picture here
Objection to relevance is the way it's phrased, Your Honor.
Let
It's
him finish his
inappropriate.
question.
Do you know whether the countertops that we see in this picture, do you know whether they've ever changed?
I do not know if they've changed, no.
Okay. In evidence is Exhibit 346 to 353. You mentioned Steam Clean was one of the contractors, right?
Yes, sir.
And you had to deal with them?
I believe I was copied on email correspondence.
Okay. And did you know that there was more work that the Paxtons wanted beyond what Steam Clean was going to do?
I wasn't that involved in the detail of the STEAM team.
Okay. Did you talk to us about how you had some involvement with an insurance adjuster?
The involvement being that I showed him the home? Yes.
And the insurance company was USAA?
I believe that's correct.
Let's look at what's in evidence of AG Exhibit 410, second page. Just catch the first page first, Eric. Can you confirm with me, Mr. Wicker, Drew,
Yes.
that the date of this correspondence from USA is September 16th, 2020?
I was saying I disagree with Silicon Player that she's angry, belligerent, or biased. These are the same kinds of objections the defense team has been making this entire time. They've been making these same kind of objections. She's just giving them a taste of their own medicine.
I do.
You know,
And do you
it's petty, but they've been petty. And so
explanation for the benefits
I disagree.
and payments and the additional payments that are laid out there?
That's what it appears to be, yes.
And how often did you hear General Paxton complain about how slow the insurance company was on his claim?
Objection, Your Honor. What's good for the goose is good for the gander. That's hearsay.
Exactly. We've been hearing from General Paxton all trial.
He's our party opponent, Your Honor, not his own. He cannot
there you go.
Statements for Ken Paxton on his behalf from the stand. We get to use them against him. He doesn't get to offer them for you.
You got it. He's right.
Here it says $32,000 total cash out to you.
He's right.
For all other covered.
She's
repairs.
right.
Do you see that?
She gets to offer statements by Paxton. He doesn't.
Involvement in trying to convince the mortgage company.
You tell her.
Release that check
you tell
to
him.
Paxton's.
I don't recall that now.
Okay. Did you understand that there were more repairs being made that Ken Paxton was claiming were covered from a different contractor?
Objection assumes facts, not in evidence, and counselors testifying.
Did you know?
Sustained.
Did you know that there was a different contractor doing some of the work in the Paxton's home?
Objection, Mr. Busby. That's twice the judge has sustained the objection to facts, not in evidence.
He just testified to it in direct that he dealt with Kevin Wood.
Yeah.
That's in evidence.
That's because it was a direct relationship based on his rational perception of the facts.
Did you deal with Mr. Wood? Did you see Mr. Wood at the home?
I did deal with Mr. Wood, yes.
Did you know that he was doing repairs and renovations to the home?
Yes.
Did you know that he was in fact the second contractor that's being referred to in the USAA docs?
No, I've never seen these documents.
Objection assumes facts, not in evidence. He's introduced a second contractor when all we know is the first and Cupertino.
I'm trying to figure out how it would be that Nate Paul's paying for repairs when in fact USAA is paying for some of them. You have any idea about that?
General Paxton expressed to me that he was paying things out of his own pocket as well as insurance.
Exactly. You knew that, for instance, the sink that they put into the home, you know that sink was replaced, right?
Objection assumes facts, not in evidence.
I'm asking him, Your Honor, how can we put it in evidence if I don't ask the witness?
Overruled.
Silly objections. You know that they were trying to replace their sink, right?
No, sir, I do not know that.
Okay. Do you know what the sink looks like now?
No, sir.
Do you know who paid for the sink?
No, sir.
Your Honor, we're going to offer AG Exhibit 433, which is all the pictures.
Objection, Your Honor.
That Angela, let me offer the exhibit first. All of the pictures that Angela Paxton had from her phone, all of these, where they were at Lowe's and Home Depot, pricing repairs to their home that they paid for out of their own pocket.
Objection, Your Honor. Assumes facts, not in evidence.
Excuse me, Counselor. Let him finish. Okay. You have plenty of time to object.
With an affidavit from Senator Paxton herself establishing that these are records that they keep, that they kept, and she confirms that they are what she say they are, and they're non-hearsay, they're mostly just pictures.
Your Honor, Mr. President, if I may respond.
Exhibit 433, all the pictures from Angela Paxton's phone.
I'm not calling Senator Paxton's credibility on this issue.
Excuse me 1 second.
Into question.
Let me ask you, do you object?
I do.
What basis?
I am not calling the affidavit itself into question. What I am saying is there is inadequate information in that packet to establish it as relevant. For example, there are about 300 pages of what looks like scrolling online shopping or photographs from catalogs from Home Depot and Lowe's. They have no point of relevance. You don't know when the pictures were taken or by whom. So while she can establish they are her records, we do not know what they imply. There's nothing to show us what they fairly and accurately depict or when it was taken.
That's what the affidavit
Mr.
does.
Busby.
The affidavit specifically does what she claims it doesn't do.
She does not claim the time frame or when the pictures were taken.
Right here, Your Honor.
Can I see the affidavit?
You may.
Nice observance, right? So you could object hearsay, right? Because these pictures being offered to demonstrate that she was doing shopping. But you could say hearsay, but she wants to go about it a different way.
Further, Mr.
Attack the
President, I would
affidavit.
point out that their business record affidavit has not been on file for 14 days, and no metadata is included, which would have been easily provided if they'd done a Celebrite dump of the cell phone.
Nice. So no business records exception. Also, I'm not sure it qualifies as a business record because it's not a business as to their home. So I'm not sure that works, but okay. Call Miss Paxton to the stand. That'll be good. Or call Mr. Paxton to the stand. What these are, or what these depict, ask a witness. These are hearsay. She should make a hearsay objection, really. These aren't business records. They're not kept by a business. They're being offered for the truth of the matter asserted. They're being offered for the truth of here's the shopping that we did. Right? They're being offered for their truth. It's hearsay.
One other point of order, Mr. President. The defense has not followed the rules established by this body in order to have a senator testify, which is de facto what is happening by affidavit. I want to encourage everyone to realize I'm not questioning that she signed what she believes to be a valid affidavit. It's that it is not in compliance with the rules, and it does not tell us what it purports to depict.
Your Honor, our mission here, this is Article 10, our mission here is to find the truth. And they have alleged that Ken Paxton and Angela Paxton, a member of this body, were bribed, that someone else paid for their house repairs. The documents you have in your hand directly contradict that and in fact prove the opposite. Those are proved up by affidavit. The pictures fairly and accurately represent pictures they were taking when they were pricing at Lowe's and Home Depot. They also have pictures of the house itself as it was undergoing renovations, and I'll compare those pictures with the pictures of the home now to demonstrate that all the things Angela Paxton wanted, like a new sink, she got.
Objection, Your Honor. Counsel continues to testify on behalf of his client. It is inappropriate. I ask that we approach and that the testimony be stricken and the senator's asked to disregard. I am not attacking a senator here, but he has to follow the rules of evidence because this is a court and we follow the rules.
Come on up. Come on up.
Yeah, they shouldn't be admitted. I mean, I don't know about the specific rules they have in terms of this. But if we were in a courtroom, this would not be admitted. These are being offered for the truth of the matter asserted. These are being offered for the truth of, I did these, I went to Home Depot, I did the shopping, here is the things I did, right? This is proof of them. This is being offered for the truth of the matter asserted. It's hearsay. It's classic hearsay. It's being offered for the truth. And so but they're not making the hearsay objection because apparently there's some special rule about senators or something or whatever. But it would be hearsay in any normal court. Right? It's you're saying that you went and you did the shopping. You're saying that you did the pricing. You're saying that you paid for it. Here's evidence of me doing the shopping. Here's evidence of me doing price comparisons. Here's evidence of me, trying to pinch the pennies because I was paying for it. That's hearsay. But maybe they have some special rule in the Senate rules for this thing because the witness is a senator. So they have some special rule. Which either way, it's bizarre because you have a juror who's also a witness. Because that's where we're at, right? It's She's not a juror, though. She's not allowed to vote, but I'm not sure whether or not that's the same thing as her not being a juror in a technical sense. We're in Bizarro world. That's where we're at. Yeah, so she might be, I mean, she's sitting there. She's sitting there. She's in the room. So if she's not a juror, what is she? Right? I mean, she's a juror that doesn't get to vote, I guess. I mean, the rules are made up and the points don't matter. It's like, at this point, I'm surprised we're not just calling a juror to the stand to testify, because that's where we're at. I mean, especially because she can't vote. But they don't want to DQ her to change the count number. So yeah, she's a juror who can't vote because they don't want to change the number. So she's still a juror. So she can't testify, I guess, because she's a juror who can't vote. And around we go. Yeah. They can call senators, but there's a different process for it. Okay. Fair. I haven't looked at the finer points of the rules of the impeachment because, you know, why? Yeah, initially she said she wouldn't recuse herself, but the Senate rules bind her from voting. Yeah, so I don't know. I don't know what's going on. Why can't laws and rules be written simply, like the Bill of Rights? Well, because people are complicated and the law deals with their complexity. The reason that laws can't be simple is because basically they always start out simple, and then, you know, but we need an exception for this. We need an exception for this. We need an exception for this. And fast forward, you know, like 1,000 years, and you wind up with this convoluted mess because it tries to deal with everyone's nuance. It's basically impossible to write a rule that's both clear and just for the vast majority of the time. It's hard to write a rule that's both clear and just. The TNG episode Justice can be brought for that, when Wesley Crusher was given the death penalty and Commander Riker said, "When has justice been as simple as a rule book?" It's like, yeah, you know, it's yeah. Reality is complex. The law has to be as complex as the reality. The life of law is not logic, but experience. That sounds pretty good. Christopher, even shall make no law doesn't mean shall make no law. It's not that simple, as we've talked about. And same thing with shall not be infringed. It's not that simple. Because the thing is, what shall we not make a law about? What shall not be infringed? And that's where things get complicated. The boundaries of the thing wind up being the most important question. At least to my mind. Or at least the most necessary question. Right? You can't talk about infringing the thing without defining the boundaries of the thing, because you need to know what you're infringing against. So some of it becomes the boundaries of it, which is a whole messy, complicated. But in Bruin, the Supreme Court points out quite rightly the test is history to understand the boundaries, because it's the right, and that would be informed by the history that informs what the right is in both the First Amendment and Second Amendment contexts. This legal philosophy and theory channel brought to you by Uncivil Law. Even if you're an absolutist, it doesn't tell you what you're absolute about. It doesn't tell you, you can be absolute about it doesn't tell you what you're absolute about. You have to define the boundaries first, even if you're an absolutist. An absolutist with respect to what? You still have to define the boundaries one way or another.
Hey.
Yeah, first shall make no law abridging. Abridging what? Abridging the freedom of speech, for example? Okay, what is the freedom of speech? That's where the thing gets complicated. The freedom of speech isn't speech. It's the freedom of speech. What is the freedom of speech? And to understand that, you have to go to the history and understand what it is and what it's not. The word "the" is a definite article. It's referring to a specific antecedent. It means a specific defined thing. We have to first define the thing before we can even talk about what it means to shall make no law or shall not be infringed. This at least is how I conceive of the idea from legal theory principles. We can't even discuss whether we're infringing or whether we're making a law regarding without first defining the thing we're talking about. It would be a little bit like talking about you cannot trespass upon the land. You have to define the boundaries of the land before you can even talk about what it means to trespass. What are the boundaries of the thing? David says it's complicated. Reason number one, people generally dislike lawyers. It's not complicated because the lawyers made it complicated. It's complicated because the people made it complicated, because behind every case there was a person, and we talk about this a little bit sometimes. We talk about this like every case is a story. Every case is a story. Miranda versus Arizona. Miranda is a guy. Gideon versus Wainwright. Gideon was a guy. Brady versus Maryland. Brady was a guy. Every case is a story. There once was a guy named, and he had this problem. And now we have to figure out what the law is with respect to him. And thus, that is how case law gets made, because it's messy. Gideon's story is hella interesting. He writes a petition on jail-ridden stationery to the U.S. Supreme Court, and they grant cert. It was hella interesting. Yeah. It's really not possible to write a law that's both simple and just. It's very, very difficult. It's very difficult to write a broad-based law that will be fair to everyone's nuances. So it depends a little bit like how much nuance you're willing to ignore, and how, like, you know, you can have an absolute rule, but like absolutes are pretty hard. It's 1,000 years of legal history has proven that it's basically impossible. We're done for lunch. We're done. We're just waiting for lunch. So I guess I got the thing on my face more covered up. So, hey, not too bad. So that's not too bad. Not possible and very difficult aren't the same. You're welcome to try. Better men than you have tried. So it may not be possible. It may not be possible. Yeah, there ought to be a law. Yeah, exactly. You know, I tend to think that the law makes sense when you sort of reason it all the way through. I find the law pretty logical. It's a very complex flowchart, but it all makes sense when you sort of think it through. At least it does to me. And so and like I think that it's more intuitive than people give credit for. At least to me. I think it kind of like I think it's more intuitive than people give credit for. Or maybe it's just me. So is the law a living, breathing entity? It depends what you mean by the question. The common law certainly is. The common law certainly is a living, breathing entity. So there's that. Contrarian gifted 5 gift memberships. Sandy gifted 50 gift memberships. Thank you very much. Alan Parker gifted 20 gift memberships. Sheree is a 99-cent uncivilian. All right, I'm going to sign off for now because I need a break. Well, actually, I wanted to try to adjudicate this thing you guys asked me about this thing Scheuer. So let's see if we can try to adjudicate this thing Scheuer from the Jan 6th thing, since we have some time. At least adjudicate it on the prima facie case. So here's what I'm going to do. As to this guy Scheuer, who from InfoWars, who's given 60 days, what I can do is I can adjudicate the prima facie case as brought out by the U.S. attorney. I can't possibly adjudicate, every possible defense or everything, like, because it's that would require like looking into every possible aspect of the case. So I can adjudicate the prima facie case as to whether or not it makes sense. So we'll do that for whatever value it has, and we'll press there. So they start with 2020. Scheuer disrupted a House Judiciary Committee and entered into a deferred agreement in 2020. He agreed not to violate any laws and perform 32 hours of service and include following special conditions for Scheuer. Defendant agrees not to utter loud, threatening, abusive language to engage disorderly conduct any place upon the United States Capitol grounds or within the buildings. Defendant agrees not to parade, demonstrate, or picket within the Capitol. The term Capitol building means Capitol, Senate House, garages, Capitol power plant, subways, closed passageways, blah, 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 blah. All right, so he enters into a specific agreement that might influence him. Capitol grounds was defined to include an area delineated on a map. Scheuer and his attorney accepted that. Okay, so there might be a special definition with respect to him because of the agreement that they reached. So, noted. Let's see. So it remained in effect. So the agreement still is in effect. So the special definition might apply to him. All right, fine. He's a Texas show. Agreed. He does the InfoWars things. He traveled to Washington, D.C. January 2021 in advance of January 6. Spoke of stopping certification electoral college. In a video posted on the website, he gave an address in Freedom Plaza. Uh-oh. In another video stated on InfoWars, Charlotte called an InfoWar live broadcast and said, "What I'm afraid of is we don't get the false certification, blah, blah, blah." In addition, Scheuer was featured in promotional material circulating InfoWars on January 5 or 6. This contains an edited graphic of Scheuer and others in front of the Capitol building. Here is a picture of him, but obviously he's not there in person. According to video footage I've reviewed, January 6, Scheuer marched to the U.S. Capitol from the ellipse. Uh-oh. On video, Scheuer marched with other individuals leading into a crowd of people in 1776 chanted something about Alex Jones. In the same video, Scheuer can be heard telling the crowd some other stuff. As Scheuer arrived in the Capitol grounds, he entered the restricted area. Uh-oh. Uh-oh. Yeah, this is a problem. This is a problem. He had an agreement. He violated the agreement. Uh-oh. Here he is, outside the Capitol, blah, blah, blah. I've reviewed another video. Depicts him within the restricted area. Uh-oh. It's not looking really good for our friend Scheuer out here. In the restricted area, at the thing, he does some things. He's publicly known based on the foregoing probable cause to knowingly enter into the grounds. And violated about willful threat, blah, 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 blah. Yeah, that looks pretty good. So yeah, they've got their prima facie case. So back to your question about what do I think about the 60-day conviction? Yeah, it looks about right. So he gets 2 months behind bars because, he did the things. There's pretty good evidence of him doing the things. He was on Capitol grounds and he specifically entered into an agreement not to enter the Capitol grounds. So yeah. So that would pretty much be the end of the game. So the prima facie case looks pretty good. What restricted area? We discussed it. They defined it in the agreement. He entered into the grounds in violation of his agreement. So yeah, the grounds were not included. Sure, they were. Do we need to go over it again? The agreement include the following special conditions. Defendant agrees not to parade, demonstrate, or picket within any Capitol building. The term Capitol buildings means United States Capitol, Senate and House office building and garages, Capitol power plant, all subways and enclosed passages connecting two or more structures, and real property underlying and enclosed by any such structure. In addition, the term United States Capitol ground was defined to include an area delineated on the map attached to the DPA, spanning the Capitol grounds from 3rd Street Northwest on the west side of the Capitol building to 2nd Street Southeast on the east side of the Capitol building. So yeah, it was defined. So no, but thank you for trying. The real property underlying and enclosed by any structure includes the area delineated on a map, spanning the Capitol grounds from 3rd Street Northwest. This is not ambiguous. You guys just don't want it to be true. But it's right there in black and white. Oh, yeah, no. You guys, yeah, it's just there. You know, it's just there. How would he know that? How would he know that? Scheuer and his attorney each signed an acceptance and the attorney acknowledgement respectfully for the deferred prosecution agreement. As a result of the deferred prosecution, Scheuer had special knowledge of what areas in Washington, D.C. in and around the Capitol. He knows because he signed the agreement. That's how he knows. Are you dense? That definition seems overly broad. Well, that's super fucking fantastic. He agreed to it. So what's your point? It's overly broad? Oh, I don't know what to tell you. He agreed to it. So, you know. What do you want? Yeah, I don't like it because my team lost is how you all sound. Exactly. Like, let's do legal analysis. This is one of the things that sometimes pisses me off sometimes, to be honest. And I think, I think, at least for some of you guys, you know, some of the questions you're asking about like Ken Paxton with respect to the conspiracy and like the evidence and I'm not seeing it and all the rest of it, I have a sneaking suspicion that if Ken Paxton was a Democrat, you wouldn't be asking the same questions. I'm just guessing. But I have a sneaking suspicion that, at least for some of you, you're going out of your way to interpret the facts favorably to Ken Paxton because he's got an R by his name and you like the guy. But that's not how we do legal analysis. I have a sneaking suspicion that many of you would not be asking the same questions or raising the same issues if Ken Paxton were a Democrat and you dislike the guy. I think some of you guys are being special pleading about it and it pisses me off a little bit. You know, I don't want it to be true because I like Ken Paxton. He's a good guy. I voted for him. I like Ken Paxton, but I don't like, you know, insert your Democrat politician of choice, even though they also were voted in by the people and blah, 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 blah. But you don't like that because, you know, you don't like those people. So I have a sneaking suspicion, for example, for the impeachment inquiry of Joe Biden, you're not going to be raising the same questions. Just guessing. Some of you guys are party overall, which, you know, I suppose, but it's not a legal analysis. I think I've been very fair to Mr. Paxton in my analysis and very neutral. I'd like to think in trying to assess it, and I've praised both sides and I've said things about both sides that I didn't like. I think I've been very fair and very neutral. And I'm like, yeah, some of this stuff, and I've also said like some of the charges are not, there's no evidence for some of the charges. Some of them are weak. Some of them look better to me. I think I've been very, very fair because the law should, you know, apply to everyone, equal justice and so forth and so on. Yeah. Yeah. Matt, we did have a legal question though, by the way, and I don't know if you would know this because it's a fairly precise criminal law question, but we'll ask you, and maybe you know, as our resident Texas attorney for the day. So we were asking the question about what level of confidence do you need to establish the conspiracy in order to present evidence that would be a hearsay exception. So there is an exception to hearsay if it's a statement by a co-conspirator. But of course, you need to know they're a co-conspirator. So like, what level of confidence do you need? Do you happen to know off the top of your head what the answer is in Texas? Because I was trying to do some research behind the scenes, and it appears that like historically, the answer has been everything from prima facie to beyond a reasonable doubt. In order to like, how much confidence do you need that the conspiracy exists in order to establish the conspiracy for the purposes of the hearsay exception? Do you happen to know the exact Texas law on this? It's a pretty precise question, but we were asking. And we saw a statement from a chief justice in the Nixon case who was completely unhelpful. So that was not great. So like, yeah. And then also, as we were doing research in the background, we also found whether or not you need evidence beyond the hearsay statement itself, which was also fun. So can you bootstrap this thing? Apparently, at least historically, there's been a split of authority on that question. So is the statement itself, which is being excluded by hearsay, enough reason to overcome the hearsay exception? So does it bootstrap itself? Apparently there's a split of authority on that. Or do you need some evidence beyond the statement to prove the conspiracy? That's also fun. I'm seeing if Matt, our resident legal expert, happens to know this fairly precise question, and then I'm going to go to lunch. They haven't discussed the standard in the case, which is also like, you know. It's a snake eating its own tail. To prove conspiracy barred, you need to use statements of a co-conspirator, which you need to prove the conspiracy. Yeah. But like, yeah, so yeah, how much is a snake eating its own tail though? It was the exact problem. So like, how confident do you need to be the conspiracy exists to establish the exception? It's a fairly precise legal question. So it is a little bit snake eating its own tail. It's just how much is it snake eating its own tail? And apparently the historical analysis is everywhere over the map. Apparently the historical analysis is every possible answer. When you're all the way from prima facie to beyond a reasonable doubt, and yes, you can, and also you can't use the statement to bootstrap itself, apparently the answer is every possible answer. Apparently the answer is just yes. Every possible answer. This is very helpful. Beyond a reasonable doubt? Is it beyond a reasonable doubt? Well, no, to ultimately prove it beyond a reasonable doubt, that's true. But do you need to prove it's beyond a reasonable doubt in the first instance? Is it beyond a reasonable doubt to be able to offer it as a hearsay exception? I mean, ultimately, you need beyond a reasonable doubt to prove the conspiracy, obviously. Although, strictly speaking, you don't need to charge them with the conspiracy to use the conspiracy exception. But let's press on. So like, yeah, ultimately you need beyond a reasonable doubt to prove the conspiracy, but how much confidence do you need to be able to overcome the hearsay exception? Is it also beyond a reasonable doubt, or is it something else? But while he's answering that, DV13 says, was present sense impression? Present sense impression is something you're literally observing as you're saying the statement. Oh, look, a car is speeding. Wow, the car's going 80 miles an hour, because you're observing it happen as you're saying it. It's literally something you're observing as you're saying it. The statement is, oh, what's the phrase? So is it? It's res gesti. It's res gesti. It is the events speaking through the statement, res gesti. How about that for some legal analysis? Boom. Boom. It is the event speaking through the statement. Res gesti. I am a real American. I fight the rights of every man. I am a real American. All right, I'm going to sign off for something we're going to vaguely call lunch. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.